Meet Vijay.
Yes.
I beg to mention item number 19 of court number 21.
Court number 21. Yes, yes. That list is not before me. This could be this. Okay, no problem. 21 of
We feel that this matter either be fixed tomorrow or on Monday.
as you wish, tomorrow or Monday. Okay. Monday, let us fix it.
I'm great.
Item number 21 of court number 21.
Item number 19
Oh.
of court number
Oh, I
21.
sorry. Item number 19 of court 21. Adjourned for the day and fixed on Monday. 112.
My lord, may I beg to listing of an item, my lord. Tomorrow, my lord, this is urgency, my lord.
Okay.
Grateful, my lord.
For listing of a criminal appeal day after tomorrow.
Obliged.
May it please, Lordship, my lord, I beg to mention, bail application number 3792 listed in court number 21, your lordship, item number 1, your lordship. Some urgency is there, your lordship, he is behind the bar, your lordship, for long, lordship.
This one, item number 1.
Item number 1 of court number 21. your lordship.
Yes.
May be taken after motion is over, your lordship. Today, your lordship, today itself, your lordship. Because he is behind the bar for long, your lordship.
All the matters are mentioned. Still urgent matters.
But where there is, so far the information derived from court number 21, your lordship. If there is any urgency, then mention could be made, your lordship.
But let's keep it tomorrow. Tomorrow.
Lordship, I beg to mention an item for listing, I for listing, tomorrow.
Tomorrow. Okay.
Next is your lordship. Lordship, I beg to mention item number 13 of 421, lordship.
Item number 13.
Admission, lordship. Here in this case, lordship, he was convicted for 3 years by the learned Chief Judicial Magistrate, lordship.
Criminal revision, right?
Criminal revision.
495.
Thereafter, he filed appeal before session judge,
That's dismissed.
lordship. And now, lordship, he filed this application before this honorable court. Lordship, kindly this matter may take today, lordship.
No, all are deferred. All are deferred. Okay, you fix it on Monday. Fix it.
Then tomorrow, lordship, tomorrow.
Tomorrow, I don't know. Tomorrow, let it be on Monday.
Lordship, Monday.
Monday.
And another matter, lordship, item 11.
13 on Monday.
Lordship, 11 also, lordship.
Same.
Lordship, AB, lordship. Tomorrow, lordship, is possible, lordship.
This can be listed tomorrow.
Lordship,
This can be listed tomorrow.
lordship. DPO, lordship.
Yeah. Yes, still no problem. Still
Lordship, with regard to court number 21.
21 is.
Item 18, Lordship. Can be on Friday, Lordship. Item 18, Lordship. Motion matter, Lordship.
Okay.
Friday, Lordship. 18, Lordship.
Obliged, lordship.
Item number 27. I majorly pass for a day, Lordship.
27
I have taken the consent of order. 27.
of this court.
Of this court. 27.
27. Diary has come. Now scan TCR.
I've taken the consent of that.
Okay. When? Next week?
Pass out for the day.
Next week.
Next week.
List after week. Interim orders there? No.
No.
May please, your lordship. Lordship, I have to make it for listing. In a motion matter, my lord, bail application, my lord, it may come on tomorrow, my lord.
Tomorrow it will be on Friday.
My lord, item, my lord, I am not available. That is why, my lord.
Okay.
May it please, your lordship. Item number 17, 18 and 17, 18, 20 and 30, my lord. Of your lordships. Court number 20.
17, 18,
20 and 30.
17, 18, 20 and 30. 30.
Can it be on? Yeah, my lord.
Oops.
Yeah.
17, 18, our court. 17, 18, 20 and 30. 30. Adjourn for the day and list on Monday.
Fine. Well, another prayer, my lord. It's of court number 21, my lord. Item number 39, my lord. Court number 21, item number 39, my lord. And today, my lord, the mandatory period will be over, my lord.
It will be over today. 60 days, 90 days. Let us 180 days. Let us fix it tomorrow. Then. Tomorrow. 181 days. That is okay. Item 39 of court 21 tomorrow.
It pleases, Lordship. My lord, item number 3 of this honorable court, Lordship.
Okay. AB.
Lordship, maybe taken in the second week of next month, Lordship, on a fixed date.
It is, it's come up for the first time. I don't.
No, no, it is for the second time.
He was called for today. I have received that case.
Okay,
CD available.
In
CD is available.
CD is available.
So when do you
CD
want?
item number 3. Item number the instruction was called for whether notice was served or not.
Oh, yes, my lord, all instruction is there.
CD is there.
CD is there.
Lordship, today I am not, I was out of station for some.
When do you want it?
Lordship, on any date, second week. Lordship.
No, my lord, second.
Second week on any.
Oh, that will be late because matter is there. No? Interim order is there,
Interim order is there.
then to be late.
Lordship, I am.
Next week?
On Monday.
Next week, I am led by learned senior counsel, Lordship. Senior counsel will not be available next week, Lordship.
No, because if interim order is there,
That is the problem, Lordship.
no, interim
Senior
order is.
counsel,
Because of that,
on the very first day of the next week, Lordship, second week, Lordship. Maybe
No,
on the very
that-
first day, Lordship.
That since interim was not there, I would have allowed. Otherwise, interim is there. Hmm.
And Lordship,
Then you take instructions and then you can mention later.
Lordship, Lordship.
When it comes up, you can mention.
May I please?
Yeah, please, Lordship. Lordship, I recommend an item number 4 from 421. This may be taken tomorrow, my lord. 21 from code 21. Motion made on my lord.
Okay.
Tomorrow, my
Of this code,
no, 21, my lord.
21 code. Item 4,
4, my lord.
item 4. Okay,
Tomorrow.
4 of 21, code number 20. Yes.
Same FR, another matter is fixed tomorrow, Lordship, this
Okay.
portion.
May I please, I beg to mention some listing to regular bill application. Lordship.
Regular bill,
Yes, Lord.
listing.
Listing, Lord. Tomorrow, Lord. This is-
Okay,
May I please, Lordship, I beg to mention a matter for listing AB for Friday.
I'm praying for listing of every matter on Friday.
May I please, Lordship, I beg to mention item 36 of my lord, code number 21, my lord. It has been listed on withdrawal column, my lord. If possible, my lord,
of code number 21,
yes, my lord.
36
For withdrawal, my lord.
so for withdrawal.
Yes.
I think we can withdraw. Your good name, please?
Yes, it's 6 of it.
S.A. Sigdar, 220. Okay, sure. Should I pass order in this?
Yeah.
No. Not it. Hmm. I cannot pass order. Okay. Okay, on the prayer of the learned council for the petitioner. S.H. Sigdar, I got naam to do. S.H. Sigdar, learned council for the petitioner, the matter is allowed to be withdrawn and accordingly stands disposed of.
Divided to file fresh one.
With a liberty to file a fresh petition.
Lordship, similar prayer in item number 35 with regard to code number 21, your lordship. For withdrawal, your lordship. With liberty to file a fresh, there's a some
Same order. 35.
liberty, your lordship.
Okay, with liberty.
Much obliged, your lordship.
May it please, your Lordship.
No problem.
May it please, your Lordship. Hello, I pray, on the instruction of my friend, I pray withdrawal item number 11 of this honorable court's list.
Item 11. You will lick it. Item 11, withdrawal, same order. Take it on order.
May I please, your Lordship. I beg to mention.
Withdrawal, 11.
I beg to mention item number 8 of this honorable court, Lordship.
8,
8.
criminal petition.
Lordship, with the consent from the other side. Can it be taken after, on second week of December, Lordship? After 10th, after 10th and
28th or 10th.
Any interim orders there?
No,
No.
no.
So, as you wish. With the consent of the other side, prays for 2 weeks adjournment, which is allowed. List the matter in the second week of December.
Lordship.
We are for listing
Much
on criminal petition. Any day, this week, Lordship. Tomorrow.
Tomorrow is a hearing actually. We already allowed so many listings. How about Monday? Monday? Let it come.
Hello,
up. Yes, tell me.
Regarding item 9, 10 and 13 lordship of this code.
9,
10 and 13 lordship.
13.
After 2 weeks lordship, charge sheeted later lordship.
9, 10 and 13.
After 2 weeks. And item 43 lordship, we are nearing to mandatory lordship, can it be on 3rd of December lordship, if possible? Item 43.
Item
Item 43
43 of this court. No?
for this code.
43. This diary is available. Stop.
3rd of December.
3rd of December. You will retain the CD
Yes. No, my lord.
for statutory period.
No, my lord, I will have to check if required, I will send that, NDPS case.
For statutory period will be over, statutory period. No, I'm asking you, will it be?
It will be 56 days on, Lordship, on the 3rd, Lordship.
Then I will have to return back the CD.
Return back the CD. Okay. This is the matter on 3/12. The diary is received and will be sent back and procured again.
May it please your lordship, I beg to mention item 32 of this honorable court.
Okay.
CD is not available. Interim may be extended and a date in maybe after vacation.
No, so, this
Your lordship may permit.
CD, my lord, no,
32.
on
Two-
18th of December.
18th of
18th of December.
Okay. CD is not received.
It
No?
is not. Interim may be extended, lordship.
Interim is extended 18/12.
Much obliged.
Lordship, one criminal application, lordship can be on first Monday, lordship.
May it please your lordship. My lord, I beg to mention item number 2 of court number 21.
Item number 2.
2 of court
Okay.
number 21.
Yeah.
The matter may be listed tomorrow, my lord.
Okay.
Obliged.
May please your lordship for lifting criminal petition on Monday, lordship.
Mhm.
No, but. Lordship, I beg to mention for listing, your lordship. Listing criminal.
Monday. Why is it not coming up in the regular course?
May please your lordship. Item number 50, my lord, may be taken after 2 weeks, my lord. CD has not received
No, item 15 of
today's list.
today's list. This court.
This court.
This court. It'll be, what is your prayer?
After 2 weeks, my lord.
Diary
It is not received.
not
The
received.
interim order may be continuable.
There's an interim order.
First week of January.
No, 2 weeks is praying.
Two-
He's on interim bill.
Yes, on 17th December.
Lordship.
15,
May I please your
17
lordship?
December of this court.
May I
Okay.
please your lordship?
Yeah.
Lordship, I beg to mention criminal petition for hearing lordship on tomorrow, lordship.
Which one? Item
No,
Li-
lordship.
for listing. Okay.
Listing.
Take a chance.
Please, your lordship, I beg to mention item number 19. The arguing counsel is out of station. Maybe the matter may be taken after 1 week, your lordship.
19 of?
19 of this court.
Yes, 19 of this.
19, my lord, as per my instruction in this case already, search sheet submitted.
Is it?
NDPS case.
So we can call for the scan report.
Commercial.
Let it come up in the normal course and then we'll adjourn it. But in the meantime, we can call for the record.
May I please your lordship?
Yes, tell me.
Item number 34 of court number 21 for withdrawal.
34. What is the prayer? For withdrawal. For withdrawal. Your good name, please.
It's Mullah on behalf of F. Hawk.
Okay, no problem. Same prayer. Allowed to be withdrawn. Full stop.
Liberty to take place.
You want a liberty also.
Just one criminal appeal was last listed in the month of June of 2025.
It's
So
not
I'm
come.
paying for a listing in the first week of April.
May it please your lordship, I beg to mention for listing of a bail with a bail application, lordship. Can it be taken on Friday, lordship?
Okay. Submit. Let us see.
I please the question. I beg to mention item number 37 of supply of court number 21, my lord.
37.
Supply court number 21, my lord, 37, my lord.
Mhm.
But this is a petition for regular bail, my lord. CD is retained, my lord. So may I pray for listing it tomorrow, my lord.
Okay.
Petitioner is there, my lord. Deeply obliged, my lord.
May please, your lordship.
37 tomorrow. Listing tomorrow.
May please, your lordship. Your lordship, I beg to mention item 24 of today's list, your lordship.
Mike,
Yes, sir.
very
Your
good.
lordship, yes. Your lordship, I have been appointed as amicus by order dated 10/11 and I received a copy on 19/11.
Okay.
I am seeking certain accommodation for preparation. Only 2 weeks' time may be granted to me. I have received.
Bail, is it scan record must have been received. You are for the respond number?
No, I'm for amicus.
Oh,
I've been
amicus for the petitioner.
Yes, I have been appointed by order dated 10/11.
Okay.
And
Bail application, right?
yes, I have received, it's a criminal, and I have received a copy on 19/11,
No, sorry, 20, item number 24.
24.
24 of my court
It's a
is a bail application.
I'm sorry then.
Now, which one?
It's
Abdul Kadir,
Just,
hearing list,
yeah.
35, sorry.
35. Criminal revision 395 of 13.
Yes,
It's old
sorry.
case for Sharma. Okay. List, okay, okay, no problem. List after 2 weeks. So let's do the matter after 2 weeks, because it's an old matter. You prepare. It must be against conviction.
Obliged.
Right. May I please the lordship? My lord, we are in jail, my lord, 2 bail applications tomorrow, my lord.
Okay.
Obliged.
May please your lordship, I beg to mention for listing of 2 criminal appeal, lordship.
Criminal appeals. Next week,
Next week, 3rd December, lordship.
Item 36 lordship, item 36 lordship.
of this court,
This court lordship.
this court.
We take after 2 weeks. Hearing matter number
Hearing.
36.
As you wish. But old matter, let's do it. We try to prepare and do it after 2 weeks.
May I please, your lordship? Not, item number 26 of court number 21. Of it, the matter is fixed for CD, and the CD has received today, I think, your lordship. So let the matter maybe come up on tomorrow, your lordship.
Item number 26 of code 21, whether regarding CD received or not regarding that matter.
For sure.
I have not.
Let us fix it on Monday.
Your lordship, he has been languishing in judicial custody for 10th of this month, your lordship. And it's very urgent, your lordship. For tomorrow's list, your lordship.
That is not sure. So. Okay.
Much obliged.
May I please, your lordship?
I beg to mention item number 21 of court number 21. Item 21, court number 21. Maybe
Criminal
come up on-
petition.
Maybe come up on Tuesday, my lord.
Okay.
Obliged.
21 Tuesday.
May I please the lordship?
Yes.
My lord, court number 21, my lord. Item number 15.
Yes. It's May.
On Friday, my lord. This Friday.
Okay.
27.
No, item 15.
15, my lord.
1481 on Friday, 20. 20. Listing. Okay. Just a minute. আমি দেখে দেওয়ার পর তো বলবো না খালি মেনশন এটা আমার কত বলে এখন মিস না দেখতে হবে কনফিউশন হবে
Item number 1.
May I please, your lordship? 4823 application, my lord. The sections are involved are 105, 125, 281, 303, T and T24, T25. My lord, there was a head-on collision between 2 vehicles. One is Swift and the Excel 100 at Dolawari, Tezpur, 35 days ago, my lord, on 23/10/25. As a result, one passenger of the Excel 10 died because that was the offending vehicle. And 2 dogs of my vehicle, that is Swift, we are traveling with 7 dogs, my lord.
Acha.
And 2 dogs were
Animal Cruelty Act is sections have been given.
only non-visible section is 105, my lord. It is applicable against the offending vehicle Excel 100. Because there was a rash and negligent driving, my lord. FIR, your lordship will get 18. The allegation against me is only that lifting of 7 number of dogs, my lord. 2 were killed in the accident and 4 were collected by the police.
Augustine Taro is
Yes.
another.
Yes, one is a student, my lord.
One is who are the petitioners? Should we just call for the diary?
My lord, 35 days have already completed, my lord. And my lord, the one Sarbigong, he's a student, my lord, of Howrah College, my lord. His examination was due, my lord, but he could not appear, my lord. That's
Just a
why
minute.
I pray that at least, my lord, both the petitioner, we are the passenger of this Swift Desire, my lord.
Just a minute. To Singhar.
35 days already completed.
Page 31 is the earlier rejection of the trial.
Okay, the vehicle driven by these two petitioners was said to be
They are the occupant,
occupants of the vehicle.
that is, Swift Desire, that is Swift.
That Swift Desire
Yes.
was
Against, offense against them is, my lord, head-on collision is there, on both the vehicle. My lord, but offending vehicle is extra 100. And my lord, my offense is that I have carried the dogs.
it was revealed that the Swift vehicle coming from Dolabari side was and driven in a rash and negligent
My lord,
manner.
both the vehicle were in negligence,
No,
and
there's a-
pedestrian died, my lord.
No, there's a-
Pedestrian driven by the axle were died, my lord. Injured and died. One died. in the-
Yes, but the thing is that the initial thing, anyway, we'll call for the case there.
My lord, 135 days already completed. Allegation against me that lifting of the cattle,
No,
that is
you
the-
submitted
that is
that,
the prevention of cruelty.
no, you
That is
submitted
valuable
that
offense.
the allegation, the accident took place due to rash and negligent driving of the axle. But the opposite fact is stated here.
My
That
lord,
it
that
is
also
caused due to the rash and
punishment
negligence.
is a punishment of the homicide and not amounting to murder. 5 years. And 35 days, my lord, nothing to be investigated, everything is there.
Whether something to be investigated or not, that none of us can decide. That's for
But
the IO to
My
decide.
lord, question is that very
We
true, my
cannot
lord.
say that there is nothing to be decided.
My lord, your lordship, you have perused the order of the additional
Where is the FIR?
FIR is at page, my lord.
Where is the FIR?
I show you, kindly, page 13, 17,
The FIR at least.
page 17,
How do I know? I do not know the fact.
page 17.
On examination of local witnesses, it was revealed that the Swift vehicle coming from Dolagari side and driven in rash and negligent manner, resulting in a collision.
Yes.
And the Xylo was thrown to the side and one person died from inside. And the
Yes.
Swift was carrying several local dogs tied up and kept inside the vehicle. Anyway, call for the call for the case diary of Testpur PS case number 708 of 2025, fixed on Monday,
Yes.
list on 112.
Lordship, it's a regular bail application, Lordship. Lordship, FIR starts at page number 14, Lordship. May I read, Lordship?
Yes.
This is to inform you that today, 3rd of October at 2:30 p.m., my minor daughter, namely so and so, went for tuition class at near Don Bosco School, Chunaigudi. And after class completed, my daughter took an e-rickshaw of the below noted accused person. The below noted accused person forcefully taken her to different places for fulfill her malafide intentions. He had taken her about 90 minutes to my daughter and used abusive and seductive sentences towards my daughter.
Lordships, the 48 notice, Lordship is not served, and the co-accused Lordship is the same ground. The co-accused already grant of bail on the honorable court, Lordship. The case, Lordship, the 38 Lordship. Publicity message to the OC Lordship, no relatives of the accused persons, Lordship.
Anyway, you get the record. You see.
Lordship, the record is available, Lordship, in J number, Lordship, 3085, Lordship.
It is, when was it disposed of?
11/11. This month. Lordship.
11/11, might have gone back. Today is 25th, 26th, might have gone back. If it
Scan
is-
copy, Lordship. Scan copy.
I'll call for it, but if it is available, it can be procured
Lordship, scan copy is there, Lordship, with the BA number, Lordship.
with the other BA number.
Yeah,
Okay.
on Friday,
No, you don't go back. It will be here only.
Friday,
Friday not possible.
Monday, Lordship,
Monday.
Monday.
Gets overloaded. So anyways,
On 5th of December.
call for the scan copy of NDPS case number 70 of 2025. Accused was arrested, pertaining to Silchar PS case 551 of 25. Accused was arrested on 24/5/2025. It is submitted that the case scan record was procured in connection with BA number
3085.
3085 of 2025,
25.
which was disposed of on 11/11/2025. Post of
Monday, Lordship.
the said scan copy, if available, in connection with the other case, shall be procured.
On
It's
Monday,
on 112.
Monday lordship.
Yes, Monday is 112, I think.
Lordship.
112.
Item number 3, motion if wait, please, your lordship.
Yes.
My lord, I mentioned this matter for
Oh, yeah.
agreement of ship.
Oh.
And my lord, I have taken instruction, here would not be available here from the 1st to 5th December lordship. So on 8th lordship, maybe then on 8th, on the very first
What
day
did
of the second week lordship. On the very first day.
December, CD is available.
CD may be written.
Retain or you want to send it back?
Send it back.
Uh,
lordship. Yes, send it back.
Your lordship may fix it on that date, my lord. I will.
Learned Counsel, Mr. Hussain,
Lordship.
uh, submitting on behalf of NJ Senior Counsel did us praise for listing it in the second week of December, as the Learned Senior Counsel would be outstation next week. The case diary has been available. The same may be retained. You'll retain it?
Yes, we'll have-
You want to retain it?
Otherwise, I will talk with the IO, my late report. I will send it back.
Okay. Then what should I write? And
Yes, my lord, your lordship, I will.
if necessary, the case diary will be returned back and procured again before the
Yes.
next date. Interim order bail granted by the order dated
1911. 1911.
My lord, matter may come up. for
coercive
bail
step.
hearing.
Huh?
Matter may come up for bail hearing.
Bail hearing.
Wrongly listed for motion.
No, case diary has not been called, it seems.
Yes.
Has it been
That
called?
Case diary was not called.
Not called, but you have received it.
Yes, but earlier instruction from the IO as to whether, but your lordship may kindly note that I have already received the case diary.
Case diary.
Case diary. Your
Okay.
lordship may fix it for bail hearing on next date. my lord.
Actually, it could have been taken up this week only. It could have been.
Yeah.
Is he available this week? No,
No, no. lordship.
this week.
This week, no lordship. Some other difficulty.
Because there is interim, that is the problem actually. Otherwise, anyway, because the investigation will also be stalled. Anyway, you send it back
Yes, ma'am.
and procure it again.
Yes,
Okay. And release the matter on 8,
8/2.
8/12.
It may be recorded, CD is already received.
Yes, I have recorded. Interim order, interim order dated 19/11/25 stands extended till the next date of listing.
Yeah.
It's not exactly a bail, no coercive measure. So
Item number 4,
Yes, the lordship. My lord, hearing this matter, my lord, the
Okay.
proceeding pending before the judicial magistrate first class.
no mention was made in the morning regarding this matter.
Regarding withdrawal of court number 21 matter, my lord.
Okay, no, yes. This one is different.
This one is not. And below the proceeding pending before the magistrate, judicial magistrate, civil is Messar Milord, and the affair was absolutely suppressing on the Bayanama agreement, Milord,
Mhm.
and relying on this affair without considering contention of the Bayanama, Milord, and charges have been filed, Milord. So I'd like to draw your lordship first the Bayanama agreement at page 11 and Annexure 1. So this type copy, I'd like to read the vernacular one like that. The vernacular one is very better, Milord.
Is that page?
Page 14, I'll read the vernacular. Page 14, my lord.
Mm.
Here, lordship will find the seller, number 2, the informant is the number 2, the Sanjay Bird. Santoshi Jain has not come, my lord. And lordship will find from bottom, উক্ত দলিল দাতা পক্ষে বিগত 10/1/17 ইংরাজি শিলচর তারিখে সিনিয়র সাব রেজিস্টার অফিসের রেজিস্ট্রারিকৃত হয়েছে আপুংটার নামার এফিডেভিট নজরুল ইসলাম বলে নিযুক্তিকৃত আমুকটার নাম আছে দীপক সেনগুপ্ত প্রেজেন্ট পিটিশনার সোয়েঞ্চো নাও মিলর দ্য বায়ানামা পত্র মিলর যেহেতু নিম্ন তফসিল বর্ণিত ভূমিতে আমি মাতৃত্ব শর্তে উত্তরাধিকারী সূত্রে সত্যবান মালিক ও দখলকারী আদ্যবধি নির্বিবাদে ভূগোল দখল করিয়াছে বর্তমান আমার নগদ টাকা অবশ্য উপরোক্ত মতে প্রাপ্ত নিম্ন তফসিল বর্ণিত ভূমি বিক্রয়ের প্রস্তাব করিলেন আপনারা তাহার খরিদ করিতে ইচ্ছুক হইয়া আপনারা সঙ্গে প্রস্তাবিত ভূমির বিক্রম মূল্য 20 to 50 lakhs টাকা সাব্যস্ত ক্রমে অদ্য আমি আপনাদের নিকট হইতে বাইনা স্বরূপ নগদ 10,50,000 টাকা গ্রহণ করিলাম এবং অত্র বাইনামা পত্র সম্পাদন অঙ্গীকার করিতেছি যে আমি দাতা আমার নিজ দায়িত্বে তফসিল বর্ণিত ভূমি বিক্রয় সংক্রান্ত যাবতীয় অনুমতি পত্র গ্রহণ করিব এবং আপনাদেরকে অবগত করাইব এবং 3 মাস মেয়াদ মধ্যে আপনাদের নিকট হইতে মূল্য অবশিষ্ট 10 লাখ নগদ সমঝিয়া পাইলে তফসিল বর্ণিত ভূমি আপনাদের নাম বরাবরে বা আপনাদের মনোনীত যে কোনো ব্যক্তিদের নাম বরাবরে বৈধ সাপ বিক্রয় করানো সম্পাদন ও রেজিস্ট্রারি করা ভূমির দখল সমঝাই দিব যদি না দেই তবে আপনারা আইনিভাবে আদালত মারফত বাইনাকৃত ভূমির কবলা রেজিস্ট্রারি করায় ভূমির দখল গ্রহণ করিতে পারবেন ইহার আমার কোনো প্রকার আপত্য গ্রাহ্য হবে না অনুমতিপত্র না পাওয়ার পর্যন্ত অত্র বাইনাপত্র বলবৎ দ্যাট মিনস আফটার রিসিভাল অফ 10,000 rupees 10 lakhs of rupees he will do all necessary action, my lord. Then, my lord, kindly have a look at the affair, my lord. Absolute suppressing fixed fact, this affair loss, my lord. Page 17 and Annexure 2. With reference to the above.
Just a minute.
Yes, my
I'm
lord.
coming to it. Yes.
With reference to the above, I beg to submit that the below named accused person, on the basis of registered power of attorney dated 25/17, executed agreement for sale by Nama dated 6/5/2017, promising to sell and convey the area of land measuring 6 kathal land covered by duct number receiving an amount of 10,50,000 as advance out of total consideration amount to 20,50,000 to me, Srimati Santoshi Jain. In the agreement for sale, my lord, this is very actually wrong facts recorded. For sale by Nama, the accused person named below promised that he will execute the sale deed within 3 months on obtaining the sale permission. But the below named accused person did not take to sale permission and did not execute the sale deed as promised by him. Later on, I came to realize that accused person always had the intention to deceive the cheat us, and that is why the other extraction money from us, execution of the agreement for sale of Bainama, promising to sell the land of 3 months, but did not take the sale permission and did not execute the sale. This is the current. Whereas in the Bainama specifically meant on after receival of remaining 10,50,000, he will execute all that. This fact has not been stated in the fact. And relying on this fact, my lord, charge sheet has been filed on 16/5/2003. The contention of the charge sheet at page 29. Before
And-
closing of the
And the case is presently at the stage of appearance.
appearance, my lord. It's a case of 406 important. In this matter, my lord, Honorable Apex Court and even this court, my lord, in the where, my lord, the criminal breach of trust and, my lord, and their cheating is totally absent. The further going to proceeding is absolutely wrong, my lord, and they're trying to give in a civil wrong in a civil case the criminal color, my lord. This is absolutely not permissible at this stage, my lord. And admittedly, my lord, he suppressed this fact. After getting remaining amount, he will execute the same. Why he has not stated this fact and relying on the affair, most casual manner, charge sheet has been filed and proceeding and cognizance taken, my lord. Cognizance, kindly have a look on page 14, my lord. Page 40. On 406 or 420, absolutely absent this ingredients of these two sections, my lord. Kindly have a look, page 40, my lord. How this 406 and 420 come when the informer himself suppressed this fact, he has not done his part, my lord, and directly lost an affair, my lord. Just to pressurize me, so such kind of processing is absolutely abuse of process.
Alternative charge can be made, but at this stage it is a cognizance, but the law is well settled that criminal breach of trust and cheating do not go parallel.
My lord.
Because in one, the transfer of property has happened illegally, in the other, the transfer of property has happened legally, but subsequently becomes illegal.
Yes.
So it's contradictory. Anyway, that's another.
Well, I have to place two citations, lordship, kindly.
At this stage, let us issue notice until the returnable date to this time. No issues. You can give me that. I'll keep it in the
Yes,
file.
my lord.
Keep it in the file. Okay.
Yes, my lord.
Third, P.K. Dekha, learned counsel for the petitioner, additional PP for the state. The the petitioner invoking section 528 BNSS is seeking quashing of criminal proceeding being PRC number 1164 of 23 pending before learned JMFC Kasar Silchar and arising out of Silchar PS case number 2036 of 23 under section 406 420 IPC. While order dated so and so. The 4-1, sorry. It had order dated 10/8/2023. The learned GMFC has been pleased to take cognizance and the case is presently at the stage of appearance. It is contended that there was an agreement to sell executed between the informant and the accused petitioner, pursuant to which the informant was to give rupees 20,50,000 and for 20,50,000, out of which the petitioner, the complainant is stated to have paid 10,50,000 10 lakhs, sorry, 10 lakhs, and after receipt of the remaining 10 lakhs 50,000, the petitioner was to execute the sale deed. The affair has been lodged with the allegation that the sale deed was not executed as promised in the agreement to sell, and that the petitioner has cheated the complainant. It is submitted, Mr. Deka, it has submitted that the FIR has been lodged suppressing material facts and the investigation done mechanically and charge sheet submitted against the
And civil in nature in this.
present petition. The dispute is, it is contended that dispute is essentially civil in nature. The petitioner side shall furnish copy to the learned additional PP representing respondent number 1 state / the petitioner shall take steps for notice upon the respondent number 2 / informant. Further, in the given facts and circumstances, till the returnable date, proceedings of PRC number 1164 of 23 before learned JMFC Silchar shall remain state. State board, to kindly make it bold, state board. Okay, list the matter on after 4 weeks.
Yes, my lord.
After list the matter after 4 weeks.
Item number 5.
Amount can easily, if you have some confusion, I will correct it. Fine.
May I please, your lordship? Hear me, lord. Petitioner has come, my lord, with a very limited parameter.
This is also, yes.
My lord, kindly page 15 is the affair, my lord. One affair loss by one Kanchan Kumar Dev, my lord. The Foxo matter, my lord. I am not the affair name accused, my lord.
Who was provided with interim relief, my lord. And petitioner number 2, my lord, he was not given the interim.
Petition 1.
1, my lord.
The BA is connected, right?
No, BA is.
VA is already disposed of, my lord. Lordship was pleased to grant.
Oh.
that bill.
In this case, my lord, charge sheet laid down.
Oh, see, it's our last order.
VD has appeared before the, my lord, the investigating agency. And he has given a statement.
Number 2, no?
2.
Charge sheet laid down on 24/11, my lord.
Okay,
24/11.
it can be disposed of, I think.
Lordship may kindly direct because one petitioner is on interim, my lord.
Yes, yes.
Lordship may kindly direct him to appear, my lord, then for regular bail, my lord.
I can seek regular bail also, but we can dispose it also, then you can appear and, submit fresh bail bonds, right? It was our previous order, you can take this 2710 order, para 1, 2, 3, the same. Good stuff. The on 27/10/2025, the petitioner number 2, Rinjim Gogoi, was granted interim bail with conditions. Good stuff. Today, the learned prosecution submits that in the meantime, upon completion of investigation, charge sheet has been submitted in the case. In view of the said development, the interim bail granted to the petitioner number 2, Rimjim Gogoi, is hereby made absolute. Further, with regard to the other petitioner, petitioner number 1, Manoj Gogoi, it is directed that in the event of his release, same conditions, no? 20,000 with 1 surety to the following conditions. That he shall, the following conditions are imposed for both of them. The petitioners shall be available for trial. If one commences, they shall not hamper or tamper with evidence. When petition stands, allowed and disposed of.
That's my lord, only one pair, my lord, regarding petitioner number 2, my lord.
2.
That one may not be made absolute, subject to consideration of your lordship's, my lord. That may be.
Okay. The learned additional PP opposes the grant of bail to the petitioners at this stage.
Bail
hearing BA, item number 12.
May please, your lordship. Lordship is under POXO, lordship. Charge sheet, yes, trial is going on.
MX.
Only ground is that violation of lordship for 40
Okay, we'll see that.
not on merit.
We'll see that also. Let the process be. Let us
Yes,
appoint an MX.
yes.
Who's available, see. Manisha is available. She's available.
Brown.
Available. Manisha, Karen Brown, MK. Learned Council is appointed as amicus for the, oh, I think already is appointed.
No, not appointed.
Item number 12.
S Das, already appointed for respondent number 2. Already appointed.
Appointed only.
Yes.
Then my lord, his name not.
Name is
shown
not shown.
in the first list.
Name may be shown.
I think, oh, no, I think there's a mistake. He's appointed and next order service on respondent 2 not yet complete.
That is a mistake in the order. Yes.
Anyway.
Yes.
Not bad.
He can be appointed. as-
But in the meantime, it is completed. Service is complete. In the meantime, I see. So let us appoint him only, since his name is reflected once. Surajit Das, full name, because Surajit Das, Learned Council, appointed as amicus curiae. The petitioner shall serve a copy to the amicus. I can take it up tomorrow or day after tomorrow.
Yes, ma'am. They have
Tomorrow. You serve him today?
Yes.
Huh. Tomorrow we'll take it up. Scan copies, scan record, scan TCR available. Okay.
Okay.
Then we'll see that notice aspect also. Both aspects we'll see.
Item number 14.
কোনটো দিছিল নে পুৰণাটো দিছিল না right.
Lordship, in this case, scan copy not received, my lord. May reminder may be issued. Otherwise, service is complete.
Yeah, are you appearing, sir?
Item number 14.
Scan copy is not received.
Not received.
Nice. POXO. So again, what about the service?
Service is complete, my lord.
Mr. Hussain,
Yes.
you are appearing for respondent 2, informant.
For the petition.
Petitioner, ma'am. Janur Ali, no?
January.
Who's by mistake, my order only. By mistake, R. Hussain appears for respondent number 2. It's a mistake problem. We have to see. Service is complete.
Service is complete, ma'am.
Amicus. So should we appoint an amicus?
Yes.
Or someone already appointed?
Yes.
But if some private councillors
Has been shown in the cost sheet.
name is shown,
Yeah. Oh, cost sheet is different.
wrong me.
Yes,
Ah,
some
wrong.
name has been shown, ma'am.
Oh, yes, no problem. No problem. So we'll wait for some time till she comes.
Yes.
You can inform her.
Yes.
Ms. Rongmei, you can inform.
That may be.
Anyway,
That may be
because
given.
TCR is not available.
Oh,
so-
TCR is not
Not
available.
available.
Sorry,
That
I
is
missed that.
not.
Okay.
Sorry.
Full stop. The petitioner as well as the informant are represented. Full stop. However, the scanned TCR not yet received. Issue reminder. List on. Yes, you are appearing for respondent number 2, right? Okay. Both of you are ready, but the record has not yet come. So we'll have to wait for some time. When should I fix it?
And this. That what one.
Next Wednesday? Third, 3/12.
Yes. Item number 16.
Wait, please, your lordship. It's a regular bail, my lord. I'm seeking bail, my lord, on the ground of, my lord, non-furnishing of the grounds, my lord. Lordship will have a look at page 98. This is the notice, my lord.
21 arrest. No?
Yes.
Was arrested in 21.
Now your lordship will have a look, my lord. Kindly have a look at page 51 for a once, please.
Yes.
My lord, this is the final complaint, my lord, page 51. Your lordship will see, my lord, my name appears at serial number 1, Goswami Dharmendra. Lordship had found it, my lord.
Yes.
Now the next page, my lord. Next page, number 2, my lord. Kamalesh Kumar, my lord.
Hmm. Yes.
Kamalesh Kumar. Now, my lord, this Kamalesh Kumar has been granted bail, my lord. That your lordship will find at page 99, my lord.
They were arrested way back in 21.
Yes, but on the same day, both were arrested.
So since 21, they are in custody.
This Kamalesh Kumar got bail, my lord.
Got
That's
bail, but the present petitioner is on custody.
Yes,
4 years.
my lord. That your lordship will find at page 99, my lord.
I've seen this order.
The operative part at page 103, my lord. 103, paragraph 14, my lord. In view of the appropriate legal proposition, it can be said that an arrested person must be informed of the grounds of his arrest and his detention, which is mandatory in nature. Admittedly, in the case in hand, there is no reflection in the arrest memo or the section 50 CRPC notice issued to the petitioner that the grounds of arrest has been informed to the petitioner at the time of arrest. Accordingly, the petitioner is entitled for bail. Same order.
Steka, you filed an objection, raised an
Yes,
objection. This is way 21, way back.
More or less same order, my lord.
Can you help me cross check this? This must be the notice, of course.
Yes.
But just, it's my duty to cross check it.
Yes, obviously.
All of lady, noticed, 50 noticed. Okay, Saleh, please. Super for a level. Order sheets are not necessary actually. Therefore, many unnecessary things come in the case record sometimes. That's why I prefer to mention this. Yes. Oh. Can I come to her?
Yes,
This is
yes,
your submission.
man.
I found this.
Man.
Same. In fact, it has some detail in the notice to the relative.
Yes.
Some little bit more. 277 drugs from trucks. But this is bland. Anyway,
Parity also, man.
anyway.
He was arrested in 2021.
21.
On this ground, Lordship, my senior already submitted on this
Yes,
ground, Lordship,
true.
section 51, earlier, on that day, Lord.
No.
And
This trial must have progressed to some extent.
We have been examined.
So only 7 weeks.
Only 7.
They should finish it. Anyway. But we'll consider,
Man.
but they should finish the trial.
Yes.
In fact, it should not have taken so many. I understand, I know the ground relatives.
Yes.
First time. But 7 witnesses and the person is in custody needs, you can speed up.
Man.
You can speed up. 7 witnesses for commercial quantities, quite less, I would say.
Man.
Anyway. Nothing can be done. He's already been in custody for a long time. আমি অলপমান ইয়াৰ পৰা ল'ব পাৰিম save us time. ধুনীয়াকৈ লিখা গৈছে বস্তু.
Page 99.
Facts we can take from it. Where is the other order?
Page 99.
Nandini Adam was there.
Page 99.
Yes, yes.
1, 3, 4, 1, 2, 3, 4, my lord, I think same.
Yes, yes. So what do you do? And it's page 99 of the book. Page 99. With the order at Asado, you can paste these 2 facts. 2 and 3 you can take. 2 and 3. Yes. It is contended, Mr. Doctor, the learned counsel for the petitioner, submits that the petitioner is in custody ever since his arrest on 7/8. Have a seat.
Right.
You sit down. Take 5 minutes. Were arrested on 7/8/2021 in connection with the with the instant case, that is NDPS case number 26 of 2022, arising out of NCB crime number 20 of 2021 under so and so sections. The case is at the stage of trial and pending for the learned additional session judge number 2, Kamrup Metro. Full stop. It is also submitted that out of the 7 listed witnesses, 4 witnesses have already been, 3 witnesses have already been examined. Full stop. You can sit down. Need to, sorry, strain. The primary contention of the learned counsel for the petitioner is that there has been non-compliance with the notice under 50 CRPC within bracket as it existed then. A copy of the notice has been annexed with the petition. Full stop. The prosecution represented by the learned standing counsel NCB, the NCB, which is the investigating agency, another comma, has submitted a written bail objection. Full stop. The allegation was about seizure of a huge quantity of suspected ganja from the 2 accused persons in their vehicle. From their in their vehicle, the ganja, the suspected ganja is quantified at how much? 275, approximately 275 kgs. Full stop. And therefore, way above the commercial quantity, which is to be above 20 kgs, which is stipulated as above 20 kgs. Full stop. The scan case record has been received, and I have perused the notice under section 50 CRPC available therein, and find that it is the same notice which has been annexed with the petition. The said notice may be reproduced herein below. You have to leave that notice. No? This one, page 97, 97, 90. You have to leave that notice. Full stop. It is also submitted from the petitioner side that a similarly placed co-accused Kamlesh Kumar was granted bail by this court on 11/4/2025 in BA 3868 of 24 on the ground of non-compliance with section 50 CRPC. Next paragraph. The law is well settled now that grounds of arrest in reasonable detail and specific to the accused person has to be provided to the accused at the time of his arrest, and it has also to be furnished to his nominated relative or person. The relevant provisions are section 47/48 VNSS, corresponding to earlier section 50, 58, 50A CRPC. Full stop. In the event of non-compliance with these stipulations, the arrest, the subsequent detention of the accused would become untenable for being violative of the constitutional provisions under Article 22(1) of the Constitution. Full stop. It has also been held that once the accused is found entitled to bail due to non-compliance with these notices, then such a right would prevail despite the existence of any statutory bars on bail. Reference may be made to the decisions of Pravir Turkasta and Bihan Kumar. Next paragraph. Coming back to the instant case, the aforesaid nature of the notice under 50 CRPC is clearly bereft of the necessary details and would not meet the stipulated standards laid down by the Honorable Supreme Court in the aforementioned cases. Of course, the arrest was in August 2021, and the judgments came much later. However, no decision has been brought to notice or has come to notice of the court, holding that the principles laid down in the aforesaid two judgments are not retrospective. Accordingly, I come to the considered opinion that the continued under trial detention of the accused petitioner would be untenable and he is required to be granted bail, also keeping in mind the aspect of parity with regard to the bail granted to co-accused. Consequently, the accused, namely so and so, same conditions will have. Yes, madam had given 2 lakhs. I will give 1 lakh.
Fine. I'm
1 lakh. No, 1 lakh for it. 2 securities or 1 security? To 1. I usually prefer 1, but these cases are slightly different. Anyway, 1 lakh with 1 security. But other things would be same. Bail conditions, no, bail conditions I'll impose. Number 1, he shall not abscond and shall be available for the remaining trial. He shall not hamper or tamper with evidence. Number 3, he shall not misuse his liberty to commit any offense, including any activities prohibited by the NDPS Act. Violation of the bail conditions would entail cancellation of the bail. The bail petition stands allowed and disposed of on the aforesaid terms. Okay?
I'm obliged.
Done. To piছত take only all of piছত দেৰিকে বহিছে ন নালাগে after something after half an hour. Process. Okay.
28 time may attend.
Please, Olaf. What's the case, my lord? Yes, you left.
Achha, your matter. 28. Yeah, tell me.
My lord, lordship may have a look, my lord. Caesar from the please.
My lord, here before my learned senior, my lord submitted, my lord. My lord, like to make one submission, my lord. My lord, this matter, my lord. Mainly, my lord, one, my lord, that is the point, my lord, the contention of the petitioner is that, my lord, that is a poppy seeds, my lord, doesn't come under the ambit of NDPS Act.
Poppy seeds.
Poppy seeds, my lord. Because that was also, my lord, that is also, my lord, says, my lord, during the course along with the others. So, my lord, in this regard, my lord, on earlier occasions, my lord, my learned senior colleague appeared, my lord. So, allow me some more time, my lord. Well, I need to go through that, my lord. Need some, my lord, more, my lord, research on that.
In the course of the day or another day?
My lord, if my lord, tomorrow, my lord, because we have, my lord, the CD, my lord, and if my learned senior, my lord, agrees
Yes,
with
there
that,
is.
my lord.
Okay. Yes, there has been received. However, learned additional PP, Mr. Boyso, seeks some time to go through it. This is the matter tomorrow, that is 27 with 7/11. Okay, we'll pick it up tomorrow.
My lord,
Let him go through. Poppy seeds, no?
Poppy seed, there's a judgment of the apex court, my lord. Poppy seed doesn't come, my lord.
It does not come.
Doesn't come. Can I give, or tomorrow I'll submit?
My lord, my learned senior will, my.
Also, this is the High Court. Seeds of poppy plant does not come within definition of opium.
Yes.
This is the Punjab Haryana High Court.
This
Must be reference to. Okay, we'll see.
Well, I have given the apex court judgment, my lord. Paragraph 26.
You have further prosecution.
Here in this case, Lordship, the material seized is, Lordship, one crust material. That is in their seizure list, Lordship, it is poppy seed crust, it has been mentioned, Lordship. But Lordship, what happened, Lordship, in Lordship, I have also got one judgment, Lordship. I think that
Paragraph 26.
This matter we are taking up tomorrow, I believe.
Tomorrow, my lord.
Tomorrow is short some time.
My lord.
So, okay, we can do some homework if we, I don't get time, but
Let the
I'm
judgment be there.
always interested to read more.
My lord.
one judgment, Lordship, may can be. It is.
Yes, it's.
Why would like it?
These numbers. No? Oh, it's sort of time being or something.
29 time being.
Yes.
Lordship, I have a simple prayer, my lord. The petitioner has been shown as absconder, my lord. In the FIR, my lord, petitioner has not been appear, my lord. And he is showing the absconder, my lord. And someone has been issued, my lord. I have simple prayer, my lord. I may be allowed to appear, my lord, on the next day, 5 my lord. And
Just read.
several order has been passed, but we are coordinating them. One is indicated. No, sir. No, sir, my. Several order has been passed, my lord. We are coordinating that further.
Here, my lord, what happened, my lord? 2 or 3 times, my lord, he was released. Again, my lord, he did not appear.
Again, warranty.
Again, warrant, again, on the strength of the warrant, my lord, he was brought before the court. Again, he defaulted.
He's the only accused.
He is the, because in this way, this is going on, my lord.
No, my lord, I am not.
That is a problem.
No, my lord.
Services and any.
Service complete, my lord.
We have to POXO, no?
Yes.
And the coordinators has been.
B. Chaudhary, Barnita Chaudhary, Learned Counsel. Is she around? She's available? Barnita Chaudhary. She's available. You can serve a copy to her. You can serve a copy to her. And we'll take it up tomorrow. Petitioner shall serve a copy.
Kadir also there, man. Amjad Kadir. Amicus.
B. Chaudhary. B. Chaudhary. Full name to defer it. Full name to. Petitioner shall serve a copy to the learned amicus. We'll take it up tomorrow. I think she's around. You just contact her.
Lordship, Visita.
No, not Vijita.
Barnita.
Bornita.
Your Lordship will be appointed on Visita. Visita Sharma. Visita Sharma. She's available.
No, Vijita's name, I know Vijita. She's standing counsel also, I think, from one of the central, but her name is not here. Single bench, might be in the division bench, her name is there. Oh, she's in the division bench. Division bench. Okay, let it be. Barnita should be available. In case of any difficulty, no, Barnita Chaudhary. In case of any difficulty, you let me know. Then before signing, I can change. I think she should be available. Tomorrow we are taking up. Okay? Tomorrow we'll take.
Item number 19.
After something. I wrote that time in a 30, Nikki.
May it please your lordship. The petitioner is behind the bar for the last. 118 days. POCSO matter. I'm not on the merit of the case, lordship. I'm only basically on the 2 grounds, lordship. One is length of detention, and number 2 is non-compliance of.
May I please, your lordship? Herein the petitioner, he is in custody for 127 days, your lord.
Okay, 123 days.
27. nothing was recovered from him, and the alleged contraventions were recovered from other accused person. And merely he has been arrested on the basis of the statement of the co-accused, Your Lordship. This 10 is the affair, Your Lordship, kindly have it.
Page 10.
10.
Okay. Diary has been received.
Diary is received, my lord.
Investigation is going on.
Going on.
Okay. Yeah. Let us
This
read
10,
the-
Your Lordship, I am reading here.
Yes, yes, you can.
The relevant part, Your Lordship.
Yes. We can read the entire one of.
Yes, yes.
I can go through it.
Yes, yes.
Yes.
I am reading here.
Yes, yes.
With reference to the subject cited above, I have the honor to state that on 19 July 2025, from 6 a.m. onwards, a routine checking operation was conducted by a team from New Bongaigaon GRP, comprising myself, Swanson, led by Swanson. At around 7:38 a.m., the New Delhi Rajdhani Express train number Swanson arrived at platform number 1 of New Bongaigaon Junction. Our team boarded coach number Swanson and commenced a search operation. During the inspection, 3 individuals were found acting suspiciously, each holding trolley bags and seated together. Upon noticing our presence, they attempt to flee with their luggage but were intercepted. A total of 4 trolley bags were recovered from their possession. Once checking the bags, 8 packets wrapped in brown tape and suspected to contain ganja were found, 2 packets in each bag. I immediately informed the OC of the New Bongaigaon GRPF Investigation Center, and approximately 7:55 a.m. SI Sanjeev Chaudhary Swanson arrived at the scene. And the 3 individuals were identified as, one is Bappi Sarkar, another one is Nabodash, and third one is Sanjay Singh. And the bottom, Your Lordship, what was recovered from Bappi Sarkar, Your Lordship? One sky blue trolley bag marked Axon containing 2 packets of suspected ganja wrapped in brown tape, approximately weight 18.8 kg, and some other, Your Lordship, mobile phone like this. And from the next test, from Nabodash, 18.7 kg ganja was recovered. And from Sanjay Singh, 19.1 kg ganja was recovered. And altogether 75.4 kg ganja was recovered.
No, actually, individual recovery has to be counted.
Yes, individual recovery was not.
There's some case law, so I don't remember now. But anyway, that's another matter. So now they must have said that it was at the behest of this petitioner.
Yes. They are the.
And
as
page
part of-
19, Your Lordship, sorry, sir. Page 17, Your Lordship, why the petitioner was arrested, Your Lordship. Page 17, Your Lordship. And during investigation, the accused person revealed that they were hired by the present petitioner, Your Lordship.
Which one, para?
Page 17, Your Lordship.
During investigation.
Yes, investigation during police custody remand, Your Lordship.
Okay.
So basically, the petitioner, he was arrested on the
Commanders
basis.
assigned to investigation. Okay, they were hired. Akash Agarwal.
Basically, the present petitioner, he was arrested on the basis of the statement of the co-accused, Your Lordship.
100 to 90 to 100 kgs per trip via train.
It is given in here.
No, no, I found other matters of.
So your Lordship is well aware about the judgment made in the
That
Tufan.
judgment is not said that automatically there cannot be conviction on the basis of that.
Yes.
But bail, as far as I know, subject to correction, is that it has not been said that if it is only on the basis of co-statement, automatically he will be entitled to bail, but it can be certainly taken into account. Now, the question is that suppose the only material available against the petitioner is the statement of co-accused. In that case, what will be your determination, nature of your determination under 37?
Yes,
Because if that is the only material at the stage of trial, then the person
at the base of trial.
will not be, he cannot be convicted.
Yes.
That means he will be, he cannot be held guilty. So can you extrapolate that and say that since at this stage only material is the statement of co-accused, therefore, he is not likely to be guilty. And therefore, section 37 is test is passed in his favor.
That is what.
Then he will get bail.
That is what their
Oh,
contention. my
I have
lord.
argued on your behalf.
Yes, yes, that is what their contention. my lord.
Sorry, I argued on your
Apart
behalf.
from that, your lordship, whether
Because
That is the law,
that is
that's it.
because
Interpretation.
yes, my lord.
But
yes.
it depends,
Depends.
if there are other materials we can consider. No, I am not saying that automatically, my question is that is one point of view. My question is that if the only material before the court while considering the bail is a statement of co-accused, even though it does not automatically, it may not automatically, entitle the accused for bail, but with regard to 37, what can you say? What will you say? That he's not likely to be guilty?
Yes,
Can he be said that?
my lord, the prospect is that, my lord.
Then only he can be granted bail.
So-
If you can say
Yes.
that
Yes.
since no conviction can be based on that,
And
he's
then-
not, then you can,
That-
then
that is
the
37 comes.
37 will be passed in his favor.
Yes, passing is.
But however, keep one thing in mind,
Yes,
even if 37 test is passed in his favor, then also you may refuse bail
he very feasible because.
because of other reasons.
Yes, and there is, because, my lord, there are two aspects, my lord. One in the case of trial, my lord, whether he will be convicted. Because lordship knows, my lord, there are several stages, my lord. Now from investigation, thereafter charge sheet, thereafter charge, thereafter, my lord, the trial starts, my lord. Now we are in the stage of, my lord, investigation. So now, my lord, lordship has to see
Kindly,
what is,
yes.
what is the prima facie material against
Yes.
them. So first, my lord, going through the investigation, my lord, first, these 4 persons were arrested, my lord, and each of the 4 persons have named this petitioner and his father, my lord, who used to, my lord, treat them as a carrier to transport these contraband items from Assam to Uttar Pradesh, my lord. And one of the statement,
Very
his own-
serious, no doubt.
his own statement is also there now, my lord. Now, the FSL has come regarding the contraband materials, that is positive. And one FSL is awaited regarding the, my lord, their, my lord, mobile phones and others, my lord. That will also throw light on them, my lord, whether contact is there or not, my lord. Because now at this stage, my lord, otherwise, my lord, they will always be scot-free, my lord, because they
No, no.
never come to the picture, my lord. Only these persons, my lord.
True.
And one of the auto rickshaw driver, my lord, he has also stated that he used to transport this and he in turn give it to the persons who.
No, he
take it.
he has referred to the petitioner.
He has also referred to the, at least, my lord, 5.
He is not an accused.
He's.
Auto
He's also an accused, my
he's
lord,
also an
after he's arrested, my lord, because.
Later.
Later, my lord, because he also stated that he used to transport this to the persons, my lord, and they in turn take it through train to Uttar Pradesh, my lord. This is going on, my lord. So at this stage, my lord, and there's also regarding, there are judgments in other way also, my lord. There are 2 judgments, my lord. One by Honorable Justice Indira Banerjee, my lord, and another is also there, my lord.
We'll see.
Where, my lord, the Tufan Singh's case has also been discussed, but, my lord, in the stage of investigation, my lord, it has been stated that 161 cannot be ignored totally, my lord. That has passed the test of Tufan Singh's, my lord. That is all, judgment is also there.
If you have, you can give it to me. Can I see the case diary once?
Yes, yes.
I just want to point out one thing, your lordship. One Rohim Ali, your lordship, who was also arrested on the basis of the statement of the co-accused.
Mhm.
I have got instruction that he has been released on bail, your lordship.
Okay.
And that is also by your
We
lordship.
can have a look at that order.
Yes.
Do you have that order? Not
No,
yet.
no, I have not ordered, your lordship. I just got the
We
number.
can get the order. We can get the order. Necessary, we can keep it for tomorrow. It's always better to have a look what the recent co-accused, what coordinate bench has said.
And that matter is still pending, your lordship. Interim protection given in
Oh,
that
okay.
case.
It has a fixed schedule.
By not this court, another court.
No, no, by this court, by your lordship.
This
It
court.
has fixed-
That's why, then it is all the more relevant to see it.
I'm checking it here.
What reasons? Okay. So I would ask specific query to the public prosecutor. Be fair, but if we leave aside, for the moment, we leave aside the statement of the co-accused, whether they were the ones caught with in the train or the auto rickshaw, whatever, and and the self-incriminating statement of the this thing. Leaving this aside, what are the other materials?
Till date, my lord, that is the.
That is the only
There
materials.
is- And their investigation is- and as per
We should
the.
not shy away from
Yes,
facts.
yes.
I have
Fact
always
is
believed.
because- because-
Fact is fact. We should
because
have
that is
the
before
courage to
lawsuits,
face
my lord.
facts.
That is before lawsuits, my lord.
So,
Lawsuit
no,
may
because I
kindly-
have not read in detail.
Yeah,
So far, whatever you have
Lawsuit
seen,
may kindly.
you have not seen other materials.
Yes, yes. The lawsuit may kindly go to the last page, my lord.
But the allegations are very serious, no doubt.
Yes, last.
100 kgs per trip.
Yes, they are doing this, my lord. Last may kindly go to the last page, my lord, but I says, my lord. they are-
Last page of the
last
case
page
diary.
of CD, my
Yes,
lord,
you have
because
flagged.
Yes, there, well, another person that is his father is yet to be arrested, my lord, and the FSL of the electronic items, my lord, that will also throw some light on their involvement.
Yes, yes, definitely.
So,
Definitely.
yeah, that is why, my lord, in these types of cases, my lord, 180 days is given, because not in all cases, my lord.
Yes, yes.
But and this is the way the investigation has to be, my lord, so far my understanding, my lord.
You're right.
Otherwise, my lord, we cannot, my lord, catch those, my lord, who are behind this, my lord, transportation drugs, my lord.
The whole thrust of the law is this, that you rehabilitate the consumers and you crack down on the peddlers and the
Yes.
traffickers.
Yes. They
That
are-
is a
they
very
are only
tough
the
thing anyway.
carriers.
But whoever, even if somebody is a trafficker, he is entitled to all the fairness and protection of all the
Okay.
constitutional rights. Okay, that is okay. That's absolutely okay. So I would like to have a look at that. He's who's the Rohim Ali,
Rohim Ali.
co-accused.
Yes.
Because his name
I have
is mentioned
brought it to the
here.
lordship. I have-
His name is mentioned there, Rohim Ali. So I would like to have a look at the order. You know.
It was on 22/10,
We
2025.
can have a look at
On
the
the
order.
day interim was granted by your lordship.
I'll have a look, do one thing. We'll take it off. Huh? So then I keep it for some time. I'll write it in the chamber. That's all.
Lordship, just when I wanted an opportunity to produce those two judgments, my lord.
Okay, then we'll
If
fix it.
lord, tomorrow.
We can also submit the.
Then your
judgment.
lordship can,
That will be better.
appreciate in the
Yes,
good
yes,
way. my
yes,
lord.
yes, definitely.
Because what the honorable court has
Yeah,
said
this
regarding.
educates us, no?
Yeah, what once regarding 160.
It helps our learning. Yes, yes. This side of the, that.
Yes, this is also from.
Because I am also looking for a pointed decision for study
Yes,
also.
that is what.
Pointed decision on this point that what should be the exact approach with
Yes.
regard to bail when this the only
Investigation-
material is the co-accused statement.
Yes, yes.
See, the Tufan Singh, which has been principle has been laid down. It's a very sound principle in law, you know, because and you know it follows as we know, you know, it actually follows from what is written in the Evidence Act only. Now even more clarified in the new act that accomplice evidence needs corroboration. It's that because the accomplice, I am a unworthy, you know, my credibility is low. I am already an accomplice. My testimony has low credibility. To escape, I may implicate someone. Therefore, we need corroboration. That principle only has been applied in the Tufan Singh, actually. No, this is what I've understood, subject to correction. Anyway, that will be fair enough. This heard Learned Council, the submits that the case diary has been received. Full stop. Both the Learned Council and the Learned Additional PP seek some time to submit some decisions. Prayer is allowed. Leave the matter tomorrow. This 27. Tomorrow or day after?
I think it will be on Friday, your lordship.
Okay.
Lord, I have no.
You have some more time? No problem.
Before that, if I can produce,
Oh, it's okay.
submit, then lordship can
You
go.
read
through-
it, then we'll
can go
also,
through,
we'll also see.
lordship can go. I am deeply obliged.
No problem.
23.
My lord, petitioner before your lordship is in jail, my lord, since 28/2025, my lord, that is 97 days to today. And he is, my lord, actually by profession is a pharmacist, my lord. He is has a pharmacy, my lord. LSD, my lord, total, my lord, 10 cough syrup, my lord, codeine cough syrup recovered from his shop, my lord. That's what he was arrested. But with FIR, my lord, relevant portion at page, my lord,
Codeine phosphate.
16, my lord.
Plus 10 bottles I found. 10 bottles.
My lord, relevant portion on page 16, my lord.
I'll just come. Yes, yes, sir. I'm on 16 only. Hmm.
10 numbers of plastic cough syrup bottle, 100 ml each containing codeine, phosphate, and thermolidine hydrochloride syrup suspected to be codeine contraband substance under NDPS Act. My lord. Now, my lord, he preferred one bail application before the learned special judge, my lord, and this order is, my lord, at page 24. My lord. And my lord, court order, I may be allowed to read out, my lord. My lord, the PS case has been registered under section 21C of the NDPS Act. The case involves alleged recovery of 10 bottles of cough syrup containing codeine codeine phosphate from the pharmacy of the accused person in his presence. Though the extent of the codeine contents in each bottle is not specified in the Ejahar or the seizure list, the letter shows that the total weight of all the bottles taken together was 1.33, that is 1 kg 33 grams, my lord, and hence I am of the considered opinion that it is most likely to come under the category of commercial quantity, that is 1 kg, my lord. For codeine, my lord, 1 kg is necessary. Therefore, so far as codeine is concerned, even if the weight of the empty bottles plastic which is light is ignored, it may be noted here that as the decision decided by the Honorable Supreme Court in the Hirashi and others versus Union of India and others reported in so and so, in the case of seizure of mixture of narcotic drugs or psychotropic substance with one or more neutral substance, the quantity of neutral substance is not to be excluded and to be taken into consideration along with actual contents by weight of the offending drug while determining the small or commercial quantity of the narcotic drugs or psychotropic substance. Therefore, the case attracts the stringent bar under section 37(1)(b) of the NDPS Act, and it is matter of record that the accused person is yet to complete the detention of 180 days by section so and so of the Act and due to so and so. It may be. Now, my lord, I beg to, my lord, refer one judgment, latest judgment of the Honorable Supreme Court, my lord, taking note of, my lord, this, my lord, Hira Singh, my lord, of the Honorable Supreme Court. Lordship, kindly have a look, my lord, this judgment, my lord. My lord, I beg to refer, my lord, paragraph, my lord, 27, 28, and 29, my lord. My lord, kindly, I may be allowed
It's
to.
a Delhi High Court. No?
Delhi High Court, my lord.
Delhi High Court judgment.
Yes, my lord. 27, my lord, paragraph, my lord, referring the Hira Singh judgment, my lord. Here, my lord, 27, the answer is not far.
Wait,
from
wait, just a minute. Entire quantity. Yes.
May I read, my lord?
Hmm.
The answer is not far to seek. The Supreme Court in Hira Singh versus Union of India has held in the case of seizure of mixture of narcotic drugs or psychotropic substance with one or more neutral substance. The quantity of neutral substance is not to be excluded and to be taken into consideration along with actual content by weight of the offending drugs, while determining the small or commercial quantity of the narcotic drugs or psychotropic substance. The term neutral substance has not been defined under the NDPS Act. However, for the purpose of reference may be had to para 10.3 of Hira Singh Supra, which read as under. At this stage, it is required to be noted that illicit drugs are seldom sold in the pure form. They are almost always adulterated or cut with other substance, often is mixed with the heroin. It causes that heroin to evaporate at a slower rate that could allow user to take the drugs faster and get a beat punch sooner. Aspiring crushes tablets, they could have enough powder to amend reversal doses of the drugs. Take the example of heroin. It is known as powder and illegal street drugs and opine derived from morphine. These drugs can easily be cut with the variety of different substances. This means that drugs dealer will add other drugs or non-intoxicating substance to the drug so that they can sell more of it at a lesser expense to themselves. Brown sugar smokes is usually made available in powder form. The substance is only about 20% heroin. The heroin is mixed with other substances like chalk powder, zinc oxide. Because of these inputs in the drugs, brown sugar is cheaper but more dangerous. These are only few examples to show and demonstrate that even mixture of narcotic drugs or psychotropic substance is more dangerous. Therefore, what is harmful or injurious is the entire mixture tablets with neutral substance and narcotic drugs or psychotropic substance. Therefore, if it is acceptable that it is only the actual contents by weight of the offending drugs which is relevant for the purpose of determining whether it would constitute small quantity or commercial quantity. In that case, the object and purpose of enactment of the NDPS Act would be frustrated. There may be fewer punishment for commercial quantity. Certainly, that would not have been the intention of the legislature. This is important, paragraph 28 to 29. From the above paragraph in Hirasing Supra, it appears that neutral substance in the context of contraband is to be understood as a substance which is mixed with the offending part of the contraband to either increase the weight of the entire contraband in order to yield higher profit or to increase potency of the contraband or in an integral part of the contraband in order to facilitate the delivery or consumption of contraband. This being the position, this court is of the prima facie view that the towels and bedsheet do not qualify to be the neutral substance and their weight cannot be included in the weight of the contraband for determining whether seized contraband is of small or commercial quantity. However, this aspect will be considered in the detail by the learned trial court during the trial and influenced by the aforesaid prima facie view. But this is important, I am relying on it. But the court cannot be unmindful of the fact that
No, I get your point. In that case, towels and bed sheets were also weight. How can it be neutral substance?
Yes.
You know that cannot be.
100 ml, my
Therefore-
lord, 10 bottles.
Therefore, my lord,
Purely commercial
in my case, this is my lord, the last paragraph, this is part is my lord, for me, my lord, important, my lord.
Yes, it's
But
really-
the court cannot unmindful of the fact that at this stage of the consideration of bail application of the petitioner, there is no material on record, my lord, to show that the weight of the actual content of the contraband, excluding the weight of 2 towels and 1 bed sheet, is of commercial quantity so as to attract the rigor of section 37 of the Act. In this case also, my lord, here, my lord, excluding the bottle, my lord.
A bottle will be excluded.
Yes,
That
my
will be
lord,
excluded.
but here, my lord, in the record, my lord, there is nothing, my lord, to show, my lord, that excluding the bottle, my lord, this contraband is commercial, my lord.
That is a valid point.
Yes, my lord.
That is a valid point.
Well, I have seen, my lord, record, my lord, but here, my lord, excluding the bottle, my lord, there is nothing to show, my lord, this is a contraband, is my lord there. And 1000 ml is equivalent to more than 1 kg, my lord. It is nothing in the records.
See, this paragraph is very interesting, 10.3 of Hira Singh. It has been explained why neutral substance needs to be calculated.
Yeah.
Earlier, logically, we should exclude. If we look at it logically, we should exclude the neutral substance. And that is what earlier Judgment Michael Raj had said. But why it has been excluded? Because of this. That this is a strategy. The drugs are made like that. It is mixed. That is why. So anyway, so
Work.
In this case, let us see a couple of facts here.
Hello.
Just a minute. When was he arrested?
मतलब 28/2025 मतलब
20,
yes only 20
28, 2025.
मतलब
Investigation is going on.
मतलब चार्ज शीटेड मतलब
My lord, substitute, my lord, only my lord, cognizance is taken, my lord.
Mhm.
So, my lord, at this stage,
Oh,
my lord.
FSL is available.
yes मतलब
Yes, my lord, everything is available, my
Because
lord.
from FSL you can make out
yes
My
मतलब
lord.
what is
that
the
that is there.
component of codeine.
Yes, codeine is there, my lord.
Should be after
And
lunch.
my lord, charge is also not framed yet, my lord. Only, my lord, it
No,
is
his
from-
contention that
Yes.
it is commercial quantity or less than intermediate quantity. That is should be possible after the FSL report, because the FSL, if it is positive for codeine phosphate, it will indicate
Yes.
this much,
Yes.
milligram. Then we can multiply it with the number of
Yes,
bottles
the number of
and that. And then we can calculate. We'll see. The diary I'll see it.
My-
We'll resume at lunch.
My-
मतलब
I like to mention, my lord, that I have gone through the, my lord, my lord, TCR, that, my lord, FSL, my lord, that report is not in the record, my lord, but mention is there, my lord, in the search sheet, my lord, column number 14, my lord, there is a mention of, my lord, FSL report, but that report, my lord, I have not found. That maybe I think call,
Charge sheet.
yes. Search sheet is there, my lord. And in the search sheet.
I'll just check. It's mentioned.
লেখা আছে
Hundred ml each in each bottle, not the codeine, the total substance
mix.
mix. That entire liquid has to be counted.
Yes.
Entire liquid.
Well, Hirasing, my lord, entire liquid.
In terms of Hirasing.
In terms of
Not the bottle, but the entire
the
liquid.
bottle.
Anyway, so
Bottle is excluded, my lord.
excluded. No, actually, the FSL report clearly indicates usually, not usually, every time. It always indicates the percentage of the quantity of codeine.
Yes, ma'am.
So I'm just checking whether it is here or not. You don't have a copy of the chart sheet?
no. Weight is not, my lord, there given, my lord. Weight was necessary, my lord. What is the total weight or, my lord, weight of each bottle?
So FSL report, I think we'll need. It's not here. What?
Yes, my lord.
FSL report. Can you check it once?
My lord,
You're not.
my lord,
it's-
once again,
No.
I'll
I forgot. You have already checked, right?
Yes.
So I think we should call for the FSL report.
Yeah, it
That will
will
be
be
better
called
for
for-
you also.
Yes.
Huh? It will be better for you.
Yes.
We should not
Findings-
without wasting much time.
Yes, ma'am.
We should call.
Findings of the, my lord, FSL report is, my lord, noted in the, my lord.
Yes,
chart
yes,
sheet.
yes.
That is what I could not find. I
That
could
is
not find the
mentioned,
chart
but my lord,
Yes, my lord, it is there, my lord.
report is.
chart sheet today. Where's the chart sheet?
Column number 14 of লেখা আছে।
In the column number 14, my lord.
Yes, that is there. Lordship has found it. That report.
No, it's order sheet. So. Okay.
Column number 14, my lord.
Can you just mark it? Mishri Bhagat, A.M. Borbhuya and B. Sharma, additional people. The list. The accused was arrested on 20 Bees Act 2025 in connection with Alakpur PS case number 56 of 25 under section 22C NDPS Act, which was charge sheeted and And now it is pending at a stage of trial has not started.
Yes, yes, yes.
Appear and pending for and pending at the stage of appearance before the learned special judge Hailakandi, right? By what is the case number? Not the NDPS case number.
Yes.
GR number is there, but I just want to see the NDPS case number once. Kindly see the NDPS case number also. It will be there. GR number to लिखिए. GR number 321 of 2025. Corresponding to, giving rise to, corresponding to GR 321 of 25, full stop. It is submitted by the learned counsel, Mr. Borgmia, that it is not clear from the materials as to whether the quantity in question, alleged quantity in question falls in the bracket of commercial quantity. Further submitting in this context that the bottles and the bottles containing the cough syrup allegedly seized from the accused petitioner have to be excluded. The scan TCR has been received, but it is found that the FSL report, though referred to in the charge sheet, is not available. Perusal of the FSL report is necessary to ascertain the quantity of codeine and the bracket in which such quantity falls. Therefore, call for a scanned copy of the FSL report from the learned court below. That will be best.
It is my lord, and special NDPS case number 15 of 2025.
Corresponding to GR so and so, and giving rise to NDPS case number 15 of 2025. Hailakandi, session judge.
It will come, my lord, from mail, my lord. So, my lord, kindly, my lord, Friday, my lord.
Friday will be too tough because I can fix it, but it will have a process. Monday or Tuesday will be better.
Well, particularly, my lord,
From your point of view also, this is necessary.
Yes.
FSL report, my lord, particularly, my lord, other records has come.
Other records, many
Only FSL report.
Yes, only FSL. Only FSL. Otherwise, it will unnecessarily burdening them. So, list the matter. Should I fix it on Tuesday?
Tuesday.
Tuesday will be 2nd. 2/12.
Obliged.
I can keep this judgment in the record.
My lord, my lord.
$24.
AB9, yes.
In this case, petition is behind the work since 8 months. Okay?
Since
In
8 months. 8 months.
NPW issued against the petitioner also.
Okay. What about informant?
The informant, my lord, yes, I have to check. Here, there is no service report, man, whether.
Let us see. Office.
24.
Scanning. Service report is awaited.
Yeah, wait, yeah. Nobody appears to.
Both of them, time of listening, different order decision.
Scan TCR was,
Scan TCR
oh,
is received. my lord.
that is received.
That is received, my lord. Only thing, my lord. Notice,
Notice this.
notice the 14.
Though scan
perhaps-
PCR is received, but
perhaps-
service upon respondent is awaited. The prosecution shall take instructions from the concerned police station regarding such service. So, this is the matter mentioned.
A short
As
date.
per lawsuits, because there are some cases are fixed here.
Mhm.
So lawsuits, as per your lawsuits.
No, Wednesday, third
Coming.
Wednesday,
Coming
next
week.
next Wednesday.
Yeah.
Is it okay? You want
Yeah.
it, this Friday will be
Difficult.
take off. 3/12. 3/12.
Then it will be by the 23/12.
3/12. 3/12.
25.
You're not happy with the date? So I advance it by 1 or 2 days, this week will not be realistic.
Lordship.
First December or
Maybe
second December.
Third, my lord,
Huh?
because
Okay.
at the town.
Okay.
Of like this.
25. Please, your lordship,
Yes.
283 application, I am behind the bar, 336 days. my lord. My lord, what happened in this case?
Since December 2024. no?
Yes.
So, no,
This fact is remains that two persons were carrying contraband. my lord.
Okay.
They were namely
Mhm.
from Ahmed and Lashkar,
Mhm.
and they were traveling in Scooty.
Mhm.
They were arrested on the Mumbai while they were traveling in Scooty,
Mhm.
and they are taken into custody from their position. Contraband 20 goods were recovered, and a case under 21C, 270, 27A, 29B of the individual were registered.
Mhm.
Interestingly, these two persons got the bail
Mhm.
on
Okay.
the ground that non-compliance of 46 and 48,
Right.
8 minutes,
Okay.
47, 48.
Okay.
So court has granted bail.
Achha.
But I was arrested
Subsequently.
subsequently, little late, that is on 13/12. But my bail was not considered on the ground that I was brought under arrest. And there is he has mentioned that in a session court that a person who is arrested under warrant cannot be applicable under section 47 48.
Well,
That is, with
That
all
is-
respect, my lord, that TCR has come just today, my lord, but I could not go through that. my lord.
achha.
But in this case is charge sheeted, my lord.
Mhm.
But your lordship will surprised to see
Mhm.
there is a provision of law in a charge sheet, my lord, there must reflect what is the material against me.
Mhm.
Here in this charge sheet, my lord, it is reflected that I am absconder.
And
they
material,
were arrested.
materials, it should be reflected.
They should
again,
be reflected.
Sometimes it is not reflected in so much detail.
Yeah,
but
nothing
at
of
least
that.
something should be reflected.
And my lord, only
Otherwise,
thing
we'll
is
have to
that,
see the underlying materials.
yes, co-accused has stated that we came here to deliver it to
This
this
person.
Milan,
Milan
Nitin
Otil.
Lashkar. So that is washed out by the judgment of this melody, this Tufan Singh. Your lordship is very much aware. Tufan Singh. Material came up before my lord Justice Kalita. He asked me to place the Tufan Singh. I brought it, but unfortunately, my lord is sick. But later, my lord, I have got another two judgment of
Yes.
24 and 2023. That is
Supreme-
one Karan Talwar and one my lord Ravi Prakash. Ravi Prakash is, a Odisha case, my lord. Ravi Prakash. For that long detention, my lord, it is a violation through under Article 21. So until today, in this case, your lordship find trial has not started.
He was arrested on 13/12.
13/12. So I'm ready to face the trial, my lord. I pray for bail, my lord. And I hope these two judgments, besides this Tufan Singh, will help your lordship to come to a proper conclusion.
Do you have?
I'm giving it.
You have not seen.
My lord, peruse that, because if only that is the material, my lord.
Yes,
At
yes.
least.
That you have to see.
Yeah, that is.
What
because
are, as
today-
I said, excluding suppose that
Excluding, yes,
material,
ma'am, that is-
what are the other materials?
Yes,
That we have
ma'am.
to see.
So today it has come, my lord. I pray for today, my lord, because if only that is the case.
Then another date will come.
And then.
Let him see.
Yes.
Yes. Thank you.
I have underlined, my lord. in both.
I can keep this, I can keep.
Yes, yes, I have brought for your lordship.
That's all. Thank you.
If only my lord, that is the case, my learned friend is a good case. my lord.
No, you just have a look.
Then I will have to
Huh.
satisfy.
You have a look. The third, let's see this also now. The scanned TCR has been received, however, the learned additional PP submits that as it has been received only today, he needs a little time to go through it and seeks another date, which is allowed. This is the matter. When should we fix it?
Next week.
Monday?
Monday?
Monday.
Monday? Okay. This is the matter on 112.
My lord, my only submission is that learned, the trial court, learned court has not considered that aspect. That in the charge sheet, what is the material issue?
Mhm.
Simply one Mr. X says that Mr. Biswas is there.
Mm.
I have come to give it to him,
Mhm.
whether I will be liable for that.
Mm.
At least for
That's
detention.
True, true. That's true.
That is to be considered.
That's to be seen.
Obliged.
Anyway. Wait a minute. Okay.
26.
That's it, that's-
Regular bail application under section 483. As per office note, there is 24/11.
It's awaited.
Service is awaited.
Awaited.
POCSO case is under.
TCR has been
Yes,
received.
we received.
It's at the stage of trial.
Trial.
Evidence is going on.
Evidence. There's some evidence.
Take the instruction.
Parties awaited.
Though TCR has been received, but service upon informant is awaited. The prosecution shall take necessary instructions and will fix it on. You suggest?
Sir, for service report, my lord.
Mhm.
Monday, man.
Take instructions. No,
Next Friday, my lord.
Can even Wednesday, man, next Wednesday, today's Wednesday. next
And I have no problem. But the
Yes,
thing is
Next
that
Wednesday.
only Friday, if we can get the instruction, okay. Wednesday will be fair
Yes.
enough.
On third.
3/12, that is.
3rd of December. Online.
3rd of December.
Supplementary BA 42.
Oh, yeah. Please, in there. Let me take also.
Yes.
Better. Oh.
That's the case, my lord.
Mhm.
Only 48 notice was not served, madam. 47 is there, arrest memo is there,
This is-
everything was
shall
there.
order.
On the last occasion, your lordship has, my lord, directed the prosecution, my lord, to take instruction whether that 48 notice was served or not.
Oh, sir, you could not find.
My lord, in
Mhm.
fact, my lord, I have taken the certified copy, my lord.
Oh, now
of
you
the-
have taken.
I have taken, my lord, but that 48 notice is not available, my lord.
Okay.
47 and the arrest memo is there.
This year using commercial quantity.
Madam, for the time being, madam, he is trying to collect the report, madam. He will obtain the report after some time, madam.
After some time.
Then day after tomorrow, ma- on Friday,
As you wish,
my
whatever.
lord, Friday.
Mm.
Let him take instruction, Friday.
Learn additional PP, seek some time to take instructions. I'll list the matter on 28 time,
Fine, I'm obliged.
28/11. So
Oh, he has got it, man. He has.
so after some time
Yes.
or on 28.
On
Please
28, on 28.
28.
Right.
Let him see it properly.
Addition item 6.
Admission আছে। এটা আছে admission। দুটো আছে না admission?
May I please, lord?
Just a minute. It was. তাৰপিছত লাভ হ'ব। তাৰপিছত orders এই দুটা orders hearing এটা গ'ল। That is 14 Yes.
But this is the case, my lord, petitioner before your lordship convicted under NI Act, my lord.
Okay.
And that was, my lord, upheld by the appellate forum, and accordingly we are before this honorable court, but we have this revision petition, my
Do
lord.
you think this will necessitate a hearing since it is
My lord.
don't you think we should admit it and, well, because conviction matter, we have to see.
And is they, if he cooperate with us, that
Because some
maybe
matters, to a limited extent, which is possible to be disposed of by, going into a limited extent, those are
That's a good
suitable for disposal at the stage of admission. But I am also aware fully as
Right.
like you,
Right.
that once it joins the line of hearing, that takes its own time.
Well, Lord.
That is also true.
And
And the
matter also-
complainant may be aggrieved. Yeah, this grievance may be more on this side.
Lord.
Anyway, we can study the matter. We can just see
My lord.
concurrent findings of fact.
Yes, concurrent finding is there. But we are arguing that we are referring to the complaint first.
Can we see the synopsis?
Yes,
You
well,
have painstakingly prepared, so let us see it.
yes, well, synopsis is there.
Brief. It's issued by the drawer. 3,15,000. Briefly.
Let page 35 onwards is the complaint mail.
The sentence is under stay, must be under stay, right? Sentence is under an order of stay.
Yes.
Bail.
Lord.
The complaint is on page.
Page 35 onwards.
Yes.
Lord, I am reading from paragraph 2. That the accused, in order to discharge his legally enforceable debts, had issued a check paying number so and so for an amount of rupees 3,15,000 only to my aforesaid client Brown in State Bank of India, Jorhat branch, Jorhat in the district of Assam, in favor of the complaint filed by the accused. That on receipt of this aforesaid check, the complainant presented this said check to his banker syndicate Dispur branch, Guwahati, so and so, so and so. That the complainant issued a notice dated so and so, so and so. Well, these are the just formalities hearing for a check bounce case. Well, facts is that one
Bigger notebook.
Let page 49. That is the evidence pillar.
We'll manage.
Let one excavator was taken into rented,
Okay.
and on the basis of that, 3 checks were handed over to the complainant.
Hmm.
And out of that,
Towards the rent.
yes, madam. And out of 3 checks, 2 checks were cleared as per stated by the complainant, my lord. But total 5 lakh rupees was given to the complainant, but they are suppressed that facts. Only they are stating that 2 checks were clear. One is 2 lakh, one is 1 lakh. But it is in evident that total 5 lakh rupees has been given. So this case is under fraudulent. On that formulation, we are trying to convince the honorable court. Page Lordship 38 of LCR. That maybe kindly have a look. LCR of 38.
This is necessary. Which document of LCR?
Lordship, a trial court record.
Yes.
Running page number 38, my lord. There is an exhibit, my lord, exhibit A.
It's tied up.
Trial court record. The below one, I think.
Oh.
Yes.
The appellate court record, trial court record. Okay, it is same. Yes. CR case report.
Yes, well.
Mhm.
Page 38, my lord, one exhibit is there of rupees 2,50,000. That is exhibit A, my lord.
Money receipt.
Money receipt, yes, 2,50,000. That is, my lord, case amount was 50,000 and my lord, check amount was 2 lakh. And that receipt was issued by the my lord, respondent here in complainant. And lordship, page 40, lordship may kindly turn of the LCR. Another my lord, exhibit is the exhibit B. That is 1,50,000. So, my lord, 2,50,000 and 1,50,000, 4 lakh.
Exhibit B at page.
Page my lord, 40.
Yes, I'm on 40 only.
40, then exhibit B is there, my lord.
Yes, yes.
Yes.
Exhibit B.
1,50,000.
41,000 something.
1,50,000, my lord. That is.
Oh, yes, it's this one.
Yes, my lord. 1,50,000 and 2,50,000, 4 lakh. And another check was, my lord, they are admitting that 1 lakh. The total 5 lakh rupees has been given for rent. But, my lord, one check, blank check was, my lord, remain with the my lord, complainant. That check has been misused in this case. That is my case. Lordship, now I am, my lord, referring the page 49, my lord, of the petition.
The law on blank check is also settled, isn't it?
Blank check.
If the signature is admitted, then the,
Signature is admitted, lordship.
that is then the, again, then you'll have to rebut the presumption. Right?
Yes, my lord.
Which you can always do, of course.
Yes, my lord.
That you can do.
Yes, my
The
lord.
next, where I should come?
Page 49, my lord, we are referring
49.
of the petition. That is the lordship, a cross examination of the my lord, complainant, respondent hearing.
Before we proceed, I'm just taking your guidance. There are some listed hearing matters also today.
My lord.
And some of them are old matters.
Yes, my lord.
13, I don't know whether there are councils ready to do it
My
also.
lord.
That I don't know. But suppose there should we try to dispose, because this will take time.
Yes, my lord.
Sometime it is.
Yes, ma'am.
Sometime. Because it is at the stage of admission. But I am also aware that if I post it for admission, then your client will be, it will
Yes,
remain
ma'am.
indefinitely. 22 matter, it will come chronologically, but in the hearing, whichever day is fixed for hearing, it will come chronologically. That means it will not come very down the list.
My lord, one date may be fixed that.
Because I don't want to waste your effort. If you argue at length and then we are not disposing, then it is not, you should preserve your effort for the day.
Admission hearing, any
No,
conflict.
admission, it is already at the stage of admission.
Lordship.
We should not delay. If we are here, not hearing it, trying to dispose it of today, it must be admitted. It should be admitted and posted for hearing on a specific day.
Well, it may be listed in admission column, lordship. Otherwise, it's difficult.
Because actually, see, I can, I understand the difficulties of council. I understand. I have seen also, but if I keep it in the admission column and fix it in a hearing day,
Yes,
and then again the all hearing matters will suffer because they will be down the list. So this is, I'm also facing this dilemma, how to handle this.
Well, any convenient day of the honorable court, we have no objection. Well, just
That's why I'm asking, if you
My
both agree, I can admit it and fix it for hearing on a particular day, say in December before vacation.
Well, it may be fixed for disposal in the admission column, lordship. It's if I'm not wrong, lordship.
No. You fear that it will not come if it's fixed for hearing. What do you say?
Yes, Your
Hmm?
I agree with my friend here.
Any convenient day of the honorable court, my lord. We have no objection.
In January.
Any convenient day, lordship. And maybe we'll have to keep it as a part hard.
No, no need, because I've not gone into it really.
Well,
We have just started. But again, okay, I agree with whatever you have prayed, I'll pass an order like that only. But the thing is that is the, you also have to guide the court, because on a hearing day, I'll fix it on a hearing day. It will remain in the admission column.
Mile.
But on that day,
Lord.
we'll all face this dilemma, that if I take up this matter in the admission stage for disposal, and there are older hearing matters, so
Yes.
it'll be, they will suffer. What to do? Frankly, I am not finding a solution. So you have to guide. So we are just going like this. Anyway, so the revision petitioner as well as the complainant / respondent number 2 are represented by respective learned counsels. The TCR in original has also been received. Both the learned counsel submits that the matter may be kept in the admission column only, and effort may be made on another day to dispose of the same.
Yes.
Otherwise, the matter is ready for hearing, ready for final hearing. Please the matter in the admission column on, then you give, you work out a date. Work out a date. Either it should be in the 3rd week or something of December, or after reopening. After reopening, and before Bihu vacation.
18th,
18, yes, well, we have no objection.
18th of December.
Don't keep it in the last 2 days, huh? Because last 2 days, as you know, you would know more than me. Last 2 days before vacation, 2-3 days, there's a lot of new matters, bail,
well.
everything. So
Last 2 days, my lord.
don't keep here too many hearing matters. Sometimes the last week becomes non-hearing day.
Yes.
So you can fix it on 17 if you
Yes.
want it before vacation, or immediately after reopening. What do you prefer? Immediately after reopening?
January.
17th, fine.
Just a minute.
17th then, my lord.
17 December.
This is all holiday. We are reopening on this 3rd, 4th. Would 7-1 be late for you? 7. Oh,
I'm okay.
26 that was it. Okay, 6th of January, 6-1. It's a Tuesday.
Mile.
Hmm?
Oblige.
List on 6-1-2025.
26, Lord.
26. 6-1-2026. The admission column. See, this kind of problems can be solved actually by technology also, and by manually also we can solve. We can make slots. Within the day, we can have fixed
Right.
slots. That this slot will be devoted to hearing. And this slot to admission matters which are seeking disposal at admission station. Then we can segregate within the day. Formally also we can do, informally also we can do.
Right.
Otherwise, some things, some certain matters find it difficult to be reached.
Okay.
Anyway,
Item number 7.
Much obliged.
maintenance matter. Madam, maintenance matter.
Yes. My lord, this petition is against my lord, a judgment passed by the
Family
principal
court.
judge, family court, my lord. On 5/7/2025,
Yes.
in FC criminal case number 138 of 21, directing the prisoner to pay ₹7,000 per month to the respondent maintenance, my lord. My lord, the case is like this, my lord. The respondent filed a case under section 125 CRPC, alleging that the petitioner and family members tortured her mentally and physically, and ultimately she had to let the matrimonial home, my lord, on 2/5/2020 due to their torture. My lord, according to her, the petitioner is a, my lord, psychotherapist, my lord. And just thereafter, my lord, she also filed another case, CR case, my lord, under section 406 and 498A, in which the petitioners and his family members are acquitted, my lord. My lord, thereafter, after the conclusion of trial, this judgment has been passed, my lord. Now, my lord, the petitioner is a jobless person, and it is known to the family members and the respondent also. Because at-
7,000.
Yes, my lord. At the time of my lord marriage, my lord, he was jobless, my lord. It is known to them, my lord. Even then, my lord, she wanted to, on the next day of marriage, my lord, she demanded that she should be kept in a different accommodation. She doesn't want to live with the family members. He has no mother, my lord. Mother died, my lord. His old father is there, my lord. But she doesn't want to live with him. And quarrel took place, my lord. And during, she only lived, she was in their house for only 5 months. That too often on, my lord. And quite often she engaged herself in quarrel and left the place of the matrimonial house. And sometimes she went to bring her, my lord. So now, my lord, the this, my lord, judgment was passed, my lord, without going to the reality of this, that the petitioner is a jobless person, my lord. And it is also, my lord, in the assets and liabilities also, my lord.
Those statements were exchanged, submitted, statements were submitted.
Yes, Lord.
Rajnish Neha, that statements, income affidavits.
Yes, Lord.
It is already in the, my lord, judgment, my lord.
It is there in the judgment.
Shown income is 0, Lordship.
He has no income, my lord. Moreover, my lord, with the same set of, my lord, facts and, my lord, evidence, my lord, she also filed a, my lord, divorce case. But that was rejected by the, my lord, the same judge, my lord, by the same principal. I kindly see, my lord, page number, my lord, 30 of my petition, my lord. This is the judgment of the divorce case, my lord. And she is a qualified, my lord. She is MA B.Ed, my lord.
And
She can maintain herself.
she claimed that he is a physiotherapist.
But that was, but it was not proved, my lord. During trial, my lord, it was not proved, my lord.
So anyway,
Kindly,
page number
my lord, kindly go through, my lord, page 28.
28.
Para 5, my lord. May I read, my lord?
Yes.
That the in her written statement evidence, the
Challenges the, my lord, the criminal proceeding which has been initiated by
Not
the.
482, not 528 BNSS, quashing proceeding. It's a quashing matter, right? But since you have mentioned Article 26, therefore it has come as WP criminal.
Now, my lord, though the matter involves about the quashing proceeding, my lord, regarding the criminal case, my lord, it is a money matter, my lord. The petitioner took loan, my lord, from the respondent authority, my lord. And
There's
the
a-
petitioner,
just-
as per information, my lord.
Just a minute, give me a minute. Because these things have to be worked out. Nobody from state of Assam is implemented. It's not necessary.
No, not necessary, my lord.
Because otherwise the government's advocate's name has to be shown. You can just assist me.
Respondent number 3, Lord.
Yes, three. All have appeared. 1 and 2, Reliance Commercial Finance Limited, Small Finance Bank. You are for Autumn Investment in Infrastructure. 1 and 2, anybody has appeared? Let's see the-
They have not appeared, most probably, Lordship.
You're Mr.
W. Rahman, my lord.
W. Rahman.
My lord.
The petitioner, let me, it
Yes,
is
sir.
written here, so let
Yes.
me, the petitioner is represented by Learned Counsel W. Rahman. Full stop. The respondent number
3, Lord.
5, the respondent number 4, State of West Bengal, is represented in this case by Learned Counsel Miss P. Bhattacharya. Vanchali. I don't know, P. Bhattacharya. It's written here in this order dated 17/9. And you are Miss?
Yasmin,
Yasmin.
respondent number 3.
Yes. Respondent number 3 is represented by S. Yashmin, learned counsel. And now 1 and 2. 1 and 2.
Who is not a necessary party, my lord? Who is not necessary party, my lord?
1 and 2. No, 1 and 2. Otherwise, they'll have to be. Bhattakur, on 17-9, actually, Parasar had appeared for state, but no state. State of Assam is not a party respondent. That's why I asked, will it be necessary or it's not necessary?
Not, my lord.
There cannot be any standing counsel for West Bengal because it's a high court. So probably she was engaged. State of West Bengal has Miss P. Bhattacharya. Is it Panchali? P. Bhattacharya could be others also. Then 1 and 2, Small Business Finance Credit Private Limited and Reliance Commercial Private Limited. Let me check other orders.
1 and 3 is the same respondent, my lord. 1 and 3, my lord. 2 is not necessary, my lord, because your lordship will find at page 35, my lord.
Just a minute.
The also 35.
Just give me a moment.
Yes, sir.
Because these things, better to be clear in the beginning.
At page 35, my lord.
Can be struck off also then.
Yes, my lord. 2 can be struck off, my lord.
Can you represent 1?
1 is also same, my lord, as per
1 and
3 only. Lord.
only 3.
Yes.
3 and 1.
And she has to have instructions.
Yes.
No, if she has instructions, she can.
My lord.
1 and 3 same according to you.
Yes.
Reliance investment, but they will have somebody, notice is served or not upon all of them. Office note, let us see the office notes.
One of Reliance. One of Reliance. Reliance commercial was
Office note dated 24/11 indicates that R2 not yet received back.
Respondent 3 is not same lordship. I'm only for respondent 3.
Three.
Page 35.
Respondent number 2, it is awaited, they say.
My lord.
I'll come to you. Just a minute. I'll come to you. Come to that. 2 is called pending. Notice was served and was the card. I think 1 is also 1 and 2 not served. 1 and 2 is remaining. Yeah, which paragraph you want to? Which page you want?
My lord, 35, my lord. Page 35, my lord.
35.
In the
Yes.
Autumn Investment and Infrastructure Limited, formerly known as the Reliance Commercial Finance Limited, my lord. The same respondent, my lord. 1 and 3 are the same, my lord, and 2 is not required in this case. That's it. This is the proceeding, my lord, which is going to be challenged here.
Autumn, Jello Building, Kolkata, Reliance Commercial. This is formerly known as Reliance Commercial Finance Limited. Will you take instructions from your client then whether you can represent? Because according to this document, it is the earlier name of this one is now known as this Autumn Infrastructure and should be struck off.
Two can be struck off, my lord. So, my lord, my humble submission before your lordship, my lord.
Yes, the petitioner has taken a loan from the respondent number 3, my lord,
Hmm.
and he wants to repay the loan amount through negotiation or mediation, my lord.
Hmm.
And if the opposite party does not have any objection, my lord, my humble submission before your lordship, my lord, can it be sent before the mediation, before the High Court mediation, my lord, for a solution, my lord, and the whole matter will be solved, my lord. If it is 20 lakhs loan was taken from the respondent authorities, my lord. If it is repaid, my lord.
And jurisdictional issue is also there, isn't it? Do we have the jurisdiction? Because it is pending before the court of Kolkata. And you are contending that they do not have jurisdiction. The court in Calcutta does not have jurisdiction, judicial magistrate.
That is the NI Act case is pending, my lord. That
Yes.
is the under challenge, my lord. But part of cause of action here arises, my lord, here in Guwahati, my lord, because the loan was taken from Guwahati and the part
No,
of
no, the criminal proceeding.
My
The
lord.
criminal proceeding is what? Complaint case number?
Complaint case, my lord.
Number? What number?
2, 3, 6, 4, 6, 6, my lord. That
24.
is
Pending
at
before?
least pending before the in the court of learned chief judicial magistrate at Kolkata.
Kolkata. So natural, I mean, logically, don't you think the Calcutta High Court will have the jurisdiction? The quashing jurisdiction? Why Guwahati High Court? I'm just asking. I'm not saying that. There must be some reason why you have filed it here. I have not gone into the matter now. But naturally, the jurisdiction, whenever we say JMFC Guwahati, the natural jurisdiction is of Guwahati High Court.
My lord.
Right?
226,
Similarly.
226, Article 226(2), my lord, has the jurisdiction to interfere with the proceedings outside the state of outside this honorable court.
Let
High
us
Court.
have a look. All
226.
these barracks again and again. Constitution of India. Anyway, today you will have to take instructions regarding 1 and 2. I will struck off.
Yes, ma'am. And
And regarding the mediation, lordship, we do not have any problem, lordship.
if it is sent
So I
to the
that can be read, but again, check the issue of jurisdiction. That Article 226. No, outside, not outside, where cause of action wholly or in part arises. Notwithstanding that the seat of such government or authority or the residence of such person is not within those territories. If that means if cause of action arises within the jurisdiction of Guwahati High Court,
yes, ma'am.
then Guwahati High Court can also exercise
Yes,
jurisdiction.
ma'am. Yes.
And probably Calcutta High Court will also have jurisdiction.
Yes, ma'am. Under the-
I'll just go through the synopsis once, then I will.
No, no.
It can be referred for mediation. If we have jurisdiction prima facie, then it can be.
Under the instruction from a client matter, they wants to settle the matter through mediation matter.
The loan account was transferred to respondent number 2. Right. Therefore, that was settled. That was settled.
Yes.
And then the NI case. came to-
NI has been filed by the respondent number 3, my lord.
No, sorry, the first complaint case was withdrawn.
Withdrawn.
Yes. Now, if the loan account is transferred to respondent number 2, will it be wise to strike off respondent number 2,
My lord.
SBFC,
Though it was transferred, but
since they are not represented?
all the dealings are done by the respondent.
Moreover, their notice is also not here. Their service notice is also not here. All dealings are done by 3.
By 3, my lord. All dealings, my lord. Notices, my lord, and everything, my lord, is being done by the respondent number 3, my lord. That is why through 3, my lord, he wants to negotiate this issue, my lord, through mediation, my lord.
It's represented by so and so. Service upon respondent number 2, naam to likh dibo, huh? This is so and so, Small Business Finance Credit Private Limited. It's not yet complete. In this context, the petitioner, learned counsel for the petitioner submits that the respondent number 2, the said respondent number 2 is not required for adjudication of this proceeding and may be struck off. Full stop. You have no objection, right? The learned counsel, Mr. Yashmin, learned counsel representing respondent number 3, does not have any objection. Full stop. The petitioner number 2, respondent number 2, namely so and so, is accordingly struck off from the list of party respondents. Full stop. The learned counsel for respondent number 3 also seeks to take instructions in the context of the submission of the petitioner counsel that the respondent number 1 is the former name of respondent number 3. So, none appears today on behalf of respondent number 4.
I am appearing.
Oh, you are appearing now.
On behalf of P. Bhattacharya.
P. Bhattacharya, Panchali?
Yes, yes.
Panchali. Sorry. Your good name, please. I'll record you. A. Bora, appearing on behalf of learned counsel, appearing on behalf of P. Bhattacharya. First. Okay, so they are seeking a reference to mediation. The prayer, the further, the prayer of the petitioner counsel for referring the matter to mediation for settlement is not is agreed to by the learned counsel for respondent number 3 and 4. Accordingly, as the petitioner is desirous of invoking ADR, the instant proceeding is referred to the mediation center of this court.
Of this court, my lord.
Of this court, of High Court Mediation Center.
My lord.
So a copy should be marked to the this registrar, this legal services committee. That's a legal aid. That's a legal aid committee. So a date has to be fixed,
Yes,
right,
madam.
for that. The parties may appear before the mediation center on. You can
After
suggest a
15
date.
days, my lord.
Hmm?
After 15 days, my lord.
Should I give a date or after 15 days?
No, a date may be fixed, my lord. After 15 days, my lord.
11, 12.
Uh,
11.
Lordship, can it be possible in January, Lordship?
Yeah, and I have no problem. Up
Yes.
to you. You decide. 3 of you decide. In the meantime, you take the instructions
Yes,
also,
sir.
right? You can take in January. I'm just giving you an update. Take it in the second week of January.
Yes, Lordship.
The week starts, January starts from Thursday, only 3 days. Then you take in that week. 5 to 9, that week you take.
5 to 9, 6 to 9.
6/1, 6 January.
6.
Huh?
Mal-
The parties may appear before the mediation center of this court on 6/1/2025. And we fix another date here for mediation report.
Mal-
List the matter in the orders column on last week of January for outcome of the.
Yes, madam.
Hmm.
After. Third week, third week of January, my lord.
27/1.
My lord.
27/1.
Highly welcome.
Obliged, my lord.
Please, your lordship. The filed this petition for quashing of FIR under Article 226 of the Constitution of India, my lord. Here, my lord,
The WL, WPC, since you have filed,
yes, my lord.
any government advocate is. Because since you have, this is a quashing matter, but you have filed as a writ petition, right? So you have implemented also, Principal Secretary, Home is Director General.
Want to put a state respondent?
State represented by government advocate, Assam.
Yes, your lordship.
You are for this?
Right.
Oh, all right.
And as per the office note dated 20th November, notice issued to the respondent number 6 is neither received by ID card nor received the return notice, my lord. Respondent 6 is the informant, my lord.
Informed. Last office note, recent, up to date, you
Yes,
must have
yes.
seen, 2011.
20.
So what do? We wait for that?
Yes, your lordship.
Or fresh steps? Wait.
Well, actually, I think he received the notice, but we have no
Okay.
idea whether he has received or not, my lord, in black and white, my lord.
Achha.
That's why, my lord, wait for some time, my lord.
No. The 6 respondents have been implemented in this petition. Respond number 1, 2, 3, and 4 are state respondents pertaining to government of Assam, and they are represented by the learned government advocate. No, 1, 2, 3, and 4
And to for a government advocate.
government advocates
Yes, sir.
by the learned government advocate. Your good name, please.
J. Besborough.
J. Besborough, learned counsel, is appearing for respond number 5. Respondent number 6 is stated to be the informant, and as per office note dated 2011-2025, the service is still awaited with regard to the said respondent. Full stop. So we'll wait for some time.
Yes, sir.
Service report is not received back, you write like that. Full stop. So service upon respond number 6 may be awaited. List the matter in the orders column on, you can suggest a date. You can suggest a date,
My lord, 17th of December,
17th of December.
just 2 days before vacation.
17/12/2025.
Obliged.
Any records or anything to be required so that we don't lose time in between?
My lord,
It's okay, everything is there.
no, my lord, record is necessary actually, my lord.
From where it has to be called? Case diary, I think, since
My
you're.
lord, actually, when I have filed this petition, I am praying for call for the record from the police station, IO, but informally I came to know that charge sheet has already been filed, my lord.
Mm. It is better to take the route of criminal petition actually, because then, you know, the prosecutor
let's-
can appear.
Yes, my
He
lord.
can coordinate with the, you know, police station, the IO. They can also, government advocate can also, but still.
my lord.
They can also.
Actually, I have raised some other issues also. That's why I have.
Yes, yes. No, so you can, the law is there. But otherwise, conventionally, it is for habeas corpus and preventive detention. Anyway, so let the next date come, let the service be complete, then we can call for the records. if necessary. It won't be records, it may be case diary. And charge sheet, you said, no, it has been submitted. Charge sheet
That
has
is
been submitted.
But informally I came to know.
Not sure. We can call for scan copy.
Charge sheet has submitted.
Submitted.
Yes,
So should we call for the scan copy?
Maybe.
That will save some time. In the meantime, call for the scan copy of the case diary and charge sheet of Nalbari PS case number 18 of 2025, right?
Yes, sir.
What has also been filed by some of the accused lawsuits.
Final, what? FR has been filed. Oh. Hmm.
Charge sheet, I guess some of the accused lawsuit I have filed.
Charge sheet has been, it is learned counsel for response number 5 submits that the charge sheet has been submitted against some of the accused persons, and the other, with regard to the other persons, they have not been sent up for trial. So we'll call for the GR number, now it will be in the court, right?
Yes, sir.
In which court is it? CJM Nalbari.
CJM Nalbari.
From the learned court below, CJM Nalbari. Anyone for hearing?
Three matters, 47.
I do.
It was 59.
Good to see you after so many years in between.
That's 39.
You have 39, okay. 37 no, is also old matter. Let's see, we have some time.
Fire laws on in the year 2013. So I am trying to get the instruction from the police station. Well, maybe in this case already final report submitted.
37.
37.
Have a seat.
37, my lord. 12 years back, my lord, FIR was lost. We have also filed this case on 2014.
No, not 39. 38, yeah, really long, since 37.
FIR was
Just a minute. Let's explore it, but
last occasion, my lord, we have take time to reconstruct this file. It was reconstructed. It was with this senior AK Purkasto, but I have also some 1 and 2. But the FIR is, my lord, annexure C, my lord. It was 25, 2013.
I was just seeing the prayer actually.
Yes.
What was it about?
My lord, 482 CRPC.
Yes, quash the FIR.
Yes, my lord. That was filed.
FIR dated
25/13.
Nunmati PS. Okay. So,
As per my instruction, just.
was there any stay?
No stay, my
There was no stay. So investigation must be.
Yes, I will get a written, already was final report submitted as per my instruction. Just now I got one
Final?
instruction,
Okay.
final report. So I will get a written instruction.
Then it gets automatically quashed unless there's that Narazi process has to be completed. That also must have been completed. Then you take instructions for that also. No? To let you know. Mr. Borua.
Yes. Guru.
And the additional PP. The petitioner had initiated this proceeding and the 482 CRPC, seeking quashing of the Nunmati, the FIR dated 27/207/2013, giving rise to Nunmati PS case number 231 of 2013, within bracket GR number 6088 of 2013. Mr. Pothaku, learned additional PP, submits that perhaps in the meantime, final report has been submitted, and he seeks some time to take instructions. Mr. Prayer is allowed. The learned prosecution shall also take instructions about the status or outcome of any protest petition filed by the informant. Then only the process would be completed. And let it remain, it will remain at the hearing stage only.
Yes, ma'am.
So
They only that much information.
yes, yes, yes. List the matter. You can suggest a date. We'll put it at the top of the hearing list. In any case, it will come because it's old matter. Still, I will mention. Because probably it has become infructuous. I've gone through these matters once, I think.
Thing is that my lord Ajay Kumar.
No, that Nunmati club. No.
Yes, he is a dancer and is
No, it
that's
has-
the indication of this wife.
No,
After that, the husband filed.
I've read this once.
Yes, my lord. And he has.
So it's not part hurt. It's not part hurt. Okay.
So our this is 406 and 420 cannot come simultaneously. That is what legal we have
Yes,
to.
yes.
Right.
That is settled now.
Yeah.
Actually, alternative charge you can frame.
Yes.
Alternative, but they cannot come together.
Together.
Delhi Race Club is one of the cases, as far as I know. Because as we know, in one, the property is transferred illegally. One property is transferred legally, then it becomes illegal. So both are contradictory. It cannot be breach of trust and anything. Anyway, so you take the instruction and suggest me a date.
16th of December.
16/12. List on 16/12/2025. In the hearing column, at the top of the hearing list, hearing column.
16 maybe next or 14 or 15.
No, we'll adjust, no problem.
I is not available.
Then 18, my lord.
18.
18.
Okay.
At the top of the hearing list. 18 is a hearing day.
That would be difficult, my lord. Your lordship may fix then earlier. I will get the instruction on 9th of December.
9th of December.
I will get them.
Hearing day.
38. 38.
Yes, how many? It's against conviction. SI Ahmed.
365 and 32.
We can go into these matters and dispose it of actually.
3 months conviction.
I will not go now because council is not there.
Yes.
Yes. Just want to see how many witnesses were examined.
Five witnesses.
Right. None appears today on behalf of the petitioner. Full stop. as reflected in order dated 10/11/25. Learned Counsel S.I. Ahmed is representing the petitioner side. P. Bothakur, learned additional PP appears for the state. List the matter on, when should we fix it? Let's fix it.
January, next, last week of January.
6/1. Whole matter, no? 5 witnesses should finish it.
39.
Let me do that. If the petitioner she filed one application under section 125 CFTC, maintenance, monthly maintenance, in the year 2012. Her case is that she was driven away from the maternal house with a 3 months old baby. Both husband and wife, they are at that point of time present, I don't know. Let's see, they were practicing advocate and Mongoldoy, let's see. So
1 minute,
I think
just 1 minute.
that's it.
Okay, so she filed a petition for maintenance
Let's see.
under 125.
Let's
That was dismissed.
Dismissed.
Against that she has come.
Let's see.
And it's been pending for so long.
Let's see.
Anyway.
Express view in some earlier cases, let's see. When one matter get admitted, final hearing, it takes long time, let's see.
Somehow,
Let's see.
but some matters have to be, admitted. Some matters have to be listed for hearing. All matters is not possible because it will consume the time of the hearing matters, which are fixed anyway. So you can try to dispose it off. You can do.
Lordship, I pray for Lordship to grant us some liberty to file an affidavit, Lordship, wherein when we want to bring to the notice of this honorable court some new facts and developments that have taken place in due course of time, Lordship. Firstly, Lordship, both the husband and wife are advocates. And the wife is right now practicing in Mongoldoy court, and she's also an MPanel advocate at various banks, Lordship. In that way, Lordship, her income is much more than the husband, Lordship.
And the respondent he's also
an
advocate.
He's not an MPanel in any organization.
He's practicing in Moldova.
Yes, sir. Second, Lordship, they were married on 8/10/2022. After 1 year, they have parted their ways, Lordship. And in 2005, one maintenance case was filed bearing number 222 of 2005, Lordship. In that case, Lordship, that was for maintenance of her son. Lordship, in that case has been disposed of, Lordship, by the JMFC Mongoldoy. Lordship, in that case, she has filed a petition bearing number 172 of 2023, where she prayed before the Honorable Court to dispose of the present suit on the ground that she has been receiving the maintenance amount on behalf of her minor son, and that her son has already attained majority, and as such, she no longer wishes to continue the present proceeding. That has been disposed of, Lordship. After, Lordship, that was filed in 2005. They were living separately from 2004. And this maintenance case was filed, Lordship, after 8 years, that is in 2012.
Now what is the state of affairs? They are living together?
No.
No, Talak was, I
They-
think Talak was there.
Oh, they have separated, dissolved.
But see, my problem is that I was appointed as legal aid counsel
Achha.
in the year 2014.
Mhm.
At that point of time, she came to High Court
Mm.
and file this
Mm.
revision petition. And now after
So many years.
That's it. If any instruction, I'll have to take it through legal aid committee.
Yes, yes.
Give us some time. We'll
Since
file
she's an advocate, may be possible to contact her in one from Mogoldoy Bar. We'll definitely have some contacts from our councils here. That will be possible. With the help of the bar, we can get a connection. You can get her number. If she comes to the bar, no. And actually, it's so all matter actually feel, but you bring those facts on record by an affidavit. But
Regarding maintenance case for her child, that is admitted also.
that is
That is admitted.
the maintenance is
In the trial.
Lordship.
disposed of. This was against the rejection.
Yes, Lordship.
This was a-
This is another maintenance case for.
For herself. Lordship.
Parcel which was rejected
Lordship.
That was rejected.
years back.
Years back.
And regarding her
In a way, actually, it has become partly infructuous because
Lordship.
if she is not married now, you know, she will not be entitled. And secondly, even otherwise, a fresh petition can be filed. Suppose she was married to get maintenance. But now, though, anyway, but we should not keep these matters pending. You know, and in the docket also it looks bad. You know, all these matters are unnecessarily pending. With a little effort, we can dispose it of this matter. Okay. Here the learned counsel. Appearing for the petitioner as legal aid counsel. Full stop. You are Mr. Satta.
Lordship W. Hawk on behalf of Mr. A. Satta.
Yeah, sorry. W. Hawk appearing learned counsel. Appearing on behalf of the leading counsel A. Satta. Full stop. The petitioner Sapna Soikia had filed this revision aggrieved by judgment and order dated 25/7/2014 in MR 43 of 12, whereby her petition under 125 CRPC seeking maintenance was dismissed. Full stop. The learned counsel for the respondent submits that due to the elapse of time, there are several new developments which he wants to bring on record through an affidavit and seek some time for the same. Where is allowed to stop. The learned counsels submit that during this time, the parties have also dissolved their marriage. No? Anyway, so this is the matter in the hearing column. Let it remain in the hearing column only. Hearing column on.
Lordship, right after vacation, Lordship.
If we can take a chance. Can it be before vacation? Because I know this, due to a little bit of effort, these things will go. Especially when she is also appearing as legal aid. Not much time is there. That's true. 3 weeks are there. Can you file on 16th December? Or do you need more time? Otherwise, it will go to say 6.
Lordship, 6 would be better.
6/1. 6/1. 26.
Obliged.
Lordship, let me pass over for the day, Lordship. The counsel for the petitioner, Lordship, he is suffering some disease, Lordship. Is anything?
That's okay. Okay, but is it against conviction?
Lordship, I have no idea.
Let us read it together. I'll not force you to do. It's a whole matter, but today or tomorrow we should dispose it of these matters. We should not.
He has done an operation.
So
It be after 1 week.
that is okay, no problem. But let us see what the matter is. Against conviction or something else. Yeah. Conviction.
53.
Appeal was dismissed. as SK Sharma Justice, as the then session judge, he cannot take it. So these all matters, you should. AW10. That's an assistant session judge. Can you guess when the incident had taken place?
Yes.
1993.
1993.
1990. So we'll fix another date. So whichever court it comes, please, we should do this matters dispose of.
Yes.
Otherwise, it is unnecessarily pending. M.R. Chaudhary
Lordship.
is recovering. It is submitted that the leading counsel M.R. Chaudhary is recovering after surgery and sick sometime. After vacation.
Lordship.
After vacation, what will be the? You choose a date. Choose a date. Then will come. 8-1.
Lordship.
8-1.
Lordship. I love it.
Study the file and you can only do.
19
You can do. No problem.
after 1 week.
No, none appears after 1 week. None appears after 1 week. CD? CD receipt?
19.
This matters was your.
In 40, I was there.
You do it today if you want to. This is against conviction.
My lord, it may be some other day.
No, no, 40 is yours. No?
40.
Which one?
You must not do that.
Sir also there, but I say it. I'm also doing.
So when should we fixed it on? Would you like to do?
My lord, I will be there, but his my lord assistant is necessary. My lord, he is.
Do it on. I've already fixed the date. 8-1. 8-1. Huh? Do it. It's all matter. Initiative.
19 charges submission.
19 already collected submission.
What section? Oh, commercial quantity. The petitioners, the two petitioners were arrested on 18/8/2025 in connection with Delhi PS case number 44 of 2025 under section so and so. Let's stop. None appears today on behalf of the petitioner side. However, learned additional PP, Mr. P. Borthakur submits that in the meantime, charge sheet has been submitted. Accordingly, call for the scanned copy of the case diary and the charge sheet from the court of the learned. Delhi would be Kasar, I think.
District Karbi Anglong.
Karbi Anglong.
Karbi Anglong.
Special, special judge. Karbi Anglong. District. This is the matter. Suggested it.
Fixed, my lord, on 18th of December.
1812.
My lord, I am, my lord, humbly requesting, my lord, the lordship may be pleased to, my lord, graciously, my lord, prepone the matter, my lord, if possible, my lord, on Friday, my lord. Item number 23, my lord, because I have received one, my lord, certified copy of the FSL report, my lord. Statutory period is 1. I have also requested.
Which one?
Item number 23.
23.
I'll submit, my lord, tomorrow, my lord, the affidavit.
Already your lordship has fixed that. Let him file the additional affidavit, my lord. In the meantime, I will also get.
Friday, my lord, kindly, my lord.
When did we fix it?
Otherwise, my lord, Tuesday.
Doesn't matter. So,
Obliged.
only 2 days difference.
You feel it?